Okay. Okay, good evening and welcome. My name is Paul Alpert and I am the Planning Board Chair. This open meeting of the Needham Planning Board for Wednesday, September 8th, 2021 is being conducted remotely, consistent with current state regulations, and is being recorded. Public access to this meeting does not ensure that there will be public participation unless required by law. This meeting will not have public comment except in connection with any hearing that is on the agenda. We have two hearings on the agenda tonight. The first is a hearing on an amendment to the zoning bylaw regarding outdoor seating. And the second is a continuation of the public hearing for 1688 Central Avenue regarding the proposal to construct a new child care facility. First, let's confirm that we have a quorum of the members of the planning board present. So when I call your name, please respond that you are present, and then I will introduce the planning department and other staff. So Marty Jacobs.
Here.
Jean McKnight.
Here.
Natasha Espada.
Here.
Adam Block.
Here.
And the chair is here, so we have a full house tonight. And the planning department members, Lee Newman, the planning director.
Present.
Alexandra Klee, our assistant planning director, associate planning director, whatever your title is, Alex.
I'm here.
Okay. And I believe that is it for our staff. Okay, as each agenda item is reached, I will introduce participants who are here to present or discuss projects and proposals. For those participating in the meeting, please be aware that others may be able to see you and hear you. Anything that you share or state will be a matter of public record. All supporting materials for this meeting, including the agenda, are available on the town's website, www.needhamma.gov, unless otherwise noted. Some meeting ground rules. The ground rules for this meeting are designed to allow for an accurate public record. Each of the speakers on our agenda will be introduced. After speakers conclude their remarks, each board member will be asked by name for any comment, questions, or motions. I may deviate from that and allow public participation before the board members when we get to 1688 Central Avenue. All votes will be by roll call. For each participant, please remember to state your name for the record before speaking. For each person from the public who is recognized to speak, please remember to state your name and address for the record before speaking. That is my spiel to open the meeting. The first item that we have on our agenda tonight is a request for temporary occupancy permit and review of zoning compliance. An amendment to a major project site plan special permit number 2016-01, 57 Dedham Ave LLC. Is the petitioner with regard to property located at 15 and 17 Oak Street in Needham. Participating in this matter, participants, please state that you are present when I call your name. George Junta Jr.
Aye.
Dave Roach, our building commissioner.
Present.
And Michael Tadaldi, the applicant.
Well, present.
Okay, thank you all. George, I give you the floor.
All right. Thank you very much, Mr. Chairman. So as indicated, sort of ostensibly, this is a request for a occupancy permit for the residential component of the building at 1517 Oak Street. And by sort of way of refreshing your recollections, some time ago, Mr. Tadoldi came in and asked for permission to occupy those residential portions. The board voted to empower Lee to authorize the occupancy subject to a few different things, such as I think receipt of as-built plans and a few other things. Since that time, I know that there was some confusion, and Lee has determined that not everything had been submitted. But more importantly, in doing the as-builts that were required, it was discovered that there was a survey error with respect to the location of Oak Street. And that survey error resulted in the building being actually located closer to Oak Street than we previously thought. It was also discovered that the setback on the site plan was measured to the wall of the building and not to the overhang. And the overhang extends out more than 2 feet from the base of the building. So with these things, we had a revised plan done, a revised as-built plan. I think you all have that. That was submitted in. And so it looked like there was going to be an issue with respect to zoning, because as the board recalls, when this project was approved, I think we were all under the belief and impression that the zoning bylaw imposed a 10-foot minimum front yard setback. Well, when this issue came up, needless to say, it was quite a shock. And in an effort to try and find some way to address the issue, I went and picked through the bylaw, essentially line by line from cover to cover. And in doing that, discovered that the actual text of the relevant section of the bylaw did not actually say what we all thought it said. And when you really drill down into it and looked at the strict letter of the bylaw, the text of the bylaw, it actually appears to not impose any front yard setback requirement on the various side streets in the Chestnut Street Business District. It only applies a front yard setback along Chestnut Street. So armed with this discovery, I then reached out both to Lee and also reached out to the building commissioner to basically vet this and advance this concept, because if in fact there is no setback on Oak Street, then the fact that there was a survey error and the fact that the original measurement was to the wall is irrelevant from a zoning perspective. But even though it may be irrelevant from a zoning perspective, we currently have a site plan that was approved that shows a certain distance. So the prior occupancy authorization or empowerment to Lee was based upon the original site plan. So we need a number of things, first of which is occupancy permit or permission to occupy the residential component based on the correct current as-built showing the actual building and its correct location relative to the correct street line. So that's the main thing we're here for this evening. Now, as a second thing, I believe we'll probably also need a de minimis change to the site plan approval. But tonight we're here just on the occupancy on the residential portion to address with that first.
You'll come back to us later for the de minimis change.
Right, and in fact, it'll probably be a request for de minimis and for full occupancy, because I think Lee and I will have to converse, but I think with this as-built plan that has now been submitted, I think the as-builts have all been submitted. I think the affidavits have been submitted. And there was one thing left open having to do with the handicap ramp in the front, but that has also been resolved. So I think we're essentially in shape to kind of close the loop on everything.
There will be a certification needed to go with this new revised as-built, and actually the zoning table of it will need to be modified to reflect this new setback. It's still referencing the old setback standards, so that needs to be updated.
All right. Easy enough. All right. So this evening we're here to essentially get a confirmatory permission to occupy the residential portion of the building.
David Roach, do you want to add anything?
I mean, George pretty much summed it up. I mean, we read through these zoning bylaws continually all the time, and sometimes we don't scrutinize them as much as we should. I've said to many people after this was pointed out to me and I read it, and I'm going on now my 9th year here, so a lot of changes have changed, with the business districts, that as I kind of read it as an outsider, I felt it was undefendable the way it was written. So Obviously we need to add some language, we need to correct it. And, it is what it is at this point. It appears that there would be a 0 setback required on Oak Street because it isn't in the Chestnut Street Business District along the sides of Chestnut Street. So unfortunately, we got a little chink in the armor.
Yep.
And it was discovered. We're gonna correct it and we move forward. But I agree with Attorney Junta's interpretation of the bylaw.
George, I have to give you credit for finding it.
Thanks, Paul.
You said that you had to read through the bylaws line by line, and I'm sitting here thinking you've been in front of us since long before I've been on the planning board. Why hadn't you done that before?
Well, I will say I've done it probably a few times over the years, and every time I find something that I didn't notice before.
Right. And in our defense, when this bylaw was drafted, David, none of the members of the current planning board were on the planning board at the time that the current zoning was drafted. And we do have on the agenda tonight a discussion of a zoning amendment in order to correct the issues that were presented by this. So, do any of the planning board members have any questions or comments? No, I guess not. In that case, can I have a motion to issue the temporary occupancy permit?
I would, Adam, do you want to?
Go ahead, Lee.
Well, I was going to recommend that the temporary occupancy permit be issued for a period of 60 days, conditioned upon receipt of the updated as-built plan to correct the zoning table as relates the required proposed existing front yard setback, the receipt of an updated certification from the land surveyor as relates compliance with the conditions of the special permit, and receipt of DPW approval of the final as-built plan, and further conditioned upon receipt within, I think, 30 days. Is that sufficient, George, to get the filing for the de minimis change for the amendment in front of the planning board to reflect the revised setback and the elimination of the handicap ramp, provided as compliant with the Architectural Access Board standards?
So moved.
Thank you, Jean.
You made it easy for us, Lee. Thank you.
Second.
Do I have a second?
Second.
I have a second, so it's been moved and seconded. Any further discussion?
The reason why I hadn't made the motion yet is I just wanted to affirm after Lee had stipulated the conditions that our building commissioner is satisfied with those conditions, and also George, that you and your client, that those conditions are satisfactory to you and or you're capable of fulfilling those requirements in a reasonable time frame.
Would you like me to
Dave,
answer that too? No, go ahead. Sorry, go ahead.
I think that's a question first for George. And for
Well,
David.
certainly on our side, I mean, those conditions are easily met. The fact that we have the revised as-built and it's now just a matter of changing the zoning table, and then the certification we essentially have in 99% form. So we just need to revise that. So that should be something that we can get in, within, I would expect, a couple of days. So that would be quick. And then with that, we can file for the de minimis as well. So it's kind of I would expect within, probably a week, we should be able to get everything in.
I would agree with that. Thank you, George.
Okay.
A question?
Yes, Jean.
I only come back from vacation a week ago and I haven't had an opportunity to drive by the building. I just want to make sure I understand what the final resolution was with regard to the handicapped ramp. Is it that it was determined not to be necessary in the front?
Yes, that's correct. The AAB sent out an email that basically indicated that as long as there is adequate signage directing handicapped persons to the handicap accessible entrance, that the ramp was not required in the front of the building. And I think part of that was the fact that there's no elevator in that vestibule area, that the handicap elevator is in the handicap accessible entrance, which is in the back.
Thank you for the clarification.
David, are you okay with everything you've heard tonight?
So point of clarification, the building as it sits right now, the residential units are complete. We are probably within the next couple of weeks, after talking to Michael, that we are going to issue permits for the commercial section of the building. So my question is that if you release occupancy for this building, that no further board action will be required for me to issue the occupancy for the commercial spaces.
We haven't done that because we're waiting to do the amendment. So I would suggest that we will release the commercial spaces at the time the amendment is done and submitted and approved.
Okay, because I think the original release was for building permits for the whole building.
Yes, building permits are fine. Occupancy permits are being segregated at this point.
So
So-
we're issuing occupancy permits, a temporary occupancy permits for the residential units only. And then for the commercial space, when you say that the plans have been submitted and approved, do you mean approved by the board or do you mean approved by you and Dave?
I mean, approved by the board. The board's going to approve a de minimis change, which is going to show the revised setback. And I imagine now that the ramp is not there, landscaping in front of the building, which the board will approve. We will then get, or Dave will get the certification from the architect when the commercial space is done, and then we can approve the occupancy of the commercial space. So I think, Dave, if they file this for the de minimis change, we can schedule it for either our September meeting, our next September meeting, or certainly the first meeting in October, and we can close it out at that point.
If I could ask a question, and I think Dave was trying to ask this, will the commissioner be able to issue a building permit application or a building permit for the commercial space? Just won't be able to issue a,
You already have your building permit, don't you?
not for the internal construction. I have people that want to lease, but I can't sign the lease unless I know I can start construction.
I think planning was fine with the building permit on the commercial space.
Just not, and we'll just have everything wrapped up before we look for any occupancy permits.
Correct.
That's what I'm understanding.
Yeah,
Yeah.
I think that that's what David's question was. Could he issue the building permit for the interior of the commercial space? And Dave, I'm hearing that the answer is yes.
I have a
Okay,
question.
and then-
Is that subject, is the building permit for the improvements in the commercial space subject to the Attorney General's assent and town meeting's affirmative vote of the change to the zoning bylaw in October?
No, because the zoning bylaw, this building conforms to the zoning bylaw as it currently exists.
Right.
And so once we,
It's not, right, it's just a future proof
correct,
of the
and
area.
then once we adopt the new bylaw, this building will be a pre-existing non-conforming,
Right.
lawful pre-existing non-conforming. Thank you, David.
There you go.
So that makes sense. I have clarity now. Thank
Yep.
you.
Okay,
I think that wraps the questions and comments.
okay. Any further questions or comments from the board? Let's take a vote. Let's start with Natasha Espada. We never start with you, Natasha. We have a motion on the floor.
If I have any questions or if I'm,
I'm asking for the vote.
oh, yes,
Jean McKnight,
Yes,
Marty Jacobs,
I abstain.
Adam Block,
Aye.
and I vote aye, so it's 4-0 with one abstention. Okay. And I think that wraps up that agenda item.
Thank you, Mr. Chairman.
You're welcome.
Yes, thank you very much.
You're welcome.
Thank you
So,
very much. Good luck.
Thank you.
Thank you, Dave Roach, too, for.
Thank you, Dave Roach.
so
All right.
I think the next item on the agenda is the proposed amendment for the
Chestnut.
Chestnut Street Business District.
Right.
So this was, I think I've got the wrong, oh, here it is. So we got a revised amendment this afternoon. And Lee, I'd like to discuss what was presented to us today in the amendment to the front setback in section 4.4.4 regarding the business district. I'd like to tighten that up because there are, in addition to the first line, there are two other places that it refers to a business district. And I was wondering that given that there's only one area in town now that is designated as the business district, which is that area along Highland Avenue between May and Rosemary, whether it still makes sense to have two setbacks, one for prior to 1952 and one post 1952.
Without, it's possible, it's one, without researching the history of that block, about when it was done and whether it encompassed the whole block. It probably encompassed the whole block. So we probably can make that change. I just don't know what that change would be now, because I don't know the history of that block. I think it predates I think it's prior to 52, but I'd have to go back and research the history of that block.
Well,
A suggestion, could we, if that's the only question, have this submitted to the select board to get the process started? And by the time we have our hearing, that research would be done.
okay,
And we could then propose that change, which I don't think would be perceived as substantive as compared with what was advertised.
okay. So with that suggestion, Lee,
I do have some questions.
okay. I just want to make the grammatical change in the two other places where it says a business district. One is on the second line.
Mhm.
And the next one is on the third line.
Okay,
We change the A to the,
okay,
and then we can submit that to the select board, and then we'll decide what we want to do about whether we want to have a 20-foot setback, a 10-foot setback, or just leave the language as it is.
I have a further suggestion.
Yeah, Jane?
That we refer to it in the first line with a capital letter, as I think is appropriate in the capital B business, capital D district.
Correct,
And I think we
Oh,
should
that's
do the
right.
same in the
Correct.
second and third lines.
exactly, yes.
okay.
Correct. Marty?
What property or properties are affected by this proposed change?
Well, there are a few properties along Oak Street.
Oh, the properties that are affected by this change essentially are the properties that are sitting within the Chestnut Street Business District and which do not front on Chestnut Street.
And those are,
Those are, let me get a map, just a minute. Would be Oak Street, Freeman Place, Chestnut Place, Marsh Road, Clyde Street, Junction, and Keith Place.
so that's about 5 or 6 properties?
No, it's more than that properties. It's more than that in properties. I mean, historically, this setback has been applied to properties on those side streets. This is the first time we're using a zero setback anywhere in that district.
So do those properties, the owners of those properties, do they know anything about what we're doing here? Did they get notice of this?
No, they'll receive, the notice will appear in the paper. I mean, the zoning notice is just basically the way the rules for zoning work. It will appear in the publication in the paper. They don't get a personal notice unless they filed something with the town clerk asking to be notified of zoning changes.
So those properties, whether it's 5 or 6 or whatever, if this were to pass the way it is now, the way it's drafted now, they will be left with a 20-foot frontage requirement?
They'll be left, no, they'll be left with this is the Chestnut Street business. Are you asking me? Oh, I'm sorry, Marty. Are you asking me about the change you're making in Chestnut Street? Or are you asking me about the business district?
No, I'm saying, right now, you've just determined by your vote that you agree that the subject property we were just dealing with is in the the Chestnut Street Business District. And
Right.
now, by virtue of your vote, has a 0 feet frontage requirement. Right?
It has, yes,
That's where that property is now. According
right,
to the vote just taken.
yes.
Are there any other properties in the Chestnut Street Business District who are subject to that same change? Who now have a 0-foot frontage, but are going to end up with a 10 or 20-foot frontage
They're going to end up with a 10-foot setback standard.
setback, and now
And
they have a
it's-
0.
Yes, and it's all those properties that are along Keith Place, the streets that I just read to you. Although this is really a correction of what has been long-term policy and what the plan was for that district. The plan for that district was to have a 10-foot setback along those streets and to have a 20-foot setback along Chestnut Street. And that's been the plan since 1989, when the center plan was done.
Do they know
So,
that?
so Marty, for every building that exists, if they are closer than 10 feet to the street, each of those buildings will be lawful pre-existing non-conforming.
And what if they're
and
not?
Those buildings continue to stand.
But what if they're not? What if somebody, one of those owners, was planning to come in and put up a building that was within 0 feet,
Right.
had 0 frontage? And now those plans are gonna go out the window.
And
What,
I will say that we are looking, I think, as the town eventually to improve some of the zoning along Chestnut and other parts of really the downtown to achieve the goals that we have not really been able to meet from prior zoning efforts.
wait a minute, how? By giving them a 10 or 20-foot frontage requirement where now it's a 0?
Well,
How does
what
that
I'm
help?
saying is, Marty, what I'm saying, Marty, is you're absolutely right. If we further disadvantage where there are property owners now that have a 0 front setback, that would suddenly by this have a 10-foot setback or perhaps 20 in certain cases, they would be disadvantaged. And they should be properly noticed, I think is what you're saying.
Well, I'm asking all of you. I think you should have notice and a chance at every opportunity to make suggestions or not. But I think it's a question for all of us. Is that fair?
Well, Marty, I guess I really
Isn't that
don't
what we have to do?
I guess I really don't understand. If we're talking about the Chestnut Street Business District.
Yeah.
Since 1989, the setback standard, as it's been interpreted for the streets that don't front on Chestnut Street, has been 10 feet. It's been applied. When the medical office building was recently built by Petrini at the intersection of Chestnut and Junction, it meets that 10-foot standard. When the
Right.
VFW building was built, it meets that 10-foot standard. That has been That was what was expressed as the goal in the planning study that was done in 1989. And that is how this zoning has been interpreted historically until tonight.
Until tonight, that's right.
Okay, and so the idea here was, because that's what the plan called for, and that's what the historical goal has been, to retain the status quo consistent with what had been historical practice and what had been recognized and recommended in the 1988 planning study.
So what you're saying is a result of what was done tonight, the current applicant was singled out for favorable treatment, and nobody else is going to get a chance to have that favorable treatment. And that was done as a result of their mistake, right? Am I reading it wrong, or am I misunderstanding something? They got favorable treatment because they made a mistake.
Well, no, they got favorable treatment because their lawyer did his job and read the bylaw and realized that there was a mistake in the bylaw. There was a hole in the bylaw that he was able to drive his Mack truck through.
That's your reading. I think it was done because the mistake was made by the developer's surveyor in drawing the plans. He misunderstood what the width of Oak Street was. And that's what caused the problem. It wasn't anybody else. The fix, I give George Junta a lot of credit for the fix he found. Good lawyering. But that's not what happened here. That's not really what's going on. What's going on was, due to George's good work, and he convinced our building commissioner of a reading, which I happen to completely disagree with. Result of all that, he got treated better. How does that make sense? I don't think there's anything fair about that. I understand what the vote, I think I understand the vote that you took, and I didn't try to stop it. But what I'm saying is, going forward, I think you got to think a little bit more about the fairness here. I don't see why they should have an advantage like this, given the history of what happened. I just don't see.
May I make a comment here?
Sure.
We also have the Chestnut Street Overlay District. And if a property owner chooses to proceed under the Chestnut Street Overlay District with their project, then they have the opportunity for a 5-foot setback. That might have been a way to resolve this particular situation, but it would mean going back with a whole new special permit process. So the owners of those properties on the side streets that Lee mentioned, although whatever they have currently built will be prior non-conforming as to dimensions, if they choose to proceed under the provisions of Chestnut Street Overlay, they can have a 5-foot setback.
Okay, 5 is not 0.
That's true.
But 5 is not 10. And Marty, I'm going to clarify that I did not vote yes on this in order to help Mr. Tadaldi. I voted yes on this because when it was pointed out what Mr. Junta found and how Mr. Roach interpreted the bylaw also based on what Mr. Junta found, and I then read the bylaw, I agreed with that interpretation.
I have no problem.
I agreed that sometimes that's what lawyers do.
Sure.
We find, I don't know whether loophole is the right word, but George found that there was a mistake in our bylaw to his client's advantage. And that's how private parties very often get the relief that they need by, in court or in front of us or whatever.
By good lawyering. And I'm not disagreeing with that. What I do disagree with is the reading of the bylaw and the interpretation given to it by our building commissioner, with all due respect. People can disagree. I disagree with that interpretation. I don't think that's a correct reading.
My concern that Marty kind of touches on here is that looking into the future, if we do try to improve the zoning overall, so we can achieve a greater scale of development in the commercial area, do we become open to being sued by any of the existing property owners because we then create a harsher condition for them to achieve with this change to the zoning bylaw than what is under their current condition. The current condition, as Marty is pointing out, is a 0 setback. And now we're going to make it 5 or 10 or 20 feet, and we're disadvantaging some. And how does that help our overall community goal of right sizing our zoning?
Well, first of all, my response to that is, first of all, as Lee pointed out, there probably aren't any other buildings that have 0 setback or are probably even within the 10-foot setback. Second, the current buildings would be lawful pre-existing non-conforming buildings, and developers can work with that. And third, I don't think we want to have 0 setbacks anywhere in town.
No, but that's just you.
That's, yeah. Are you comfortable having a 0 setback along those streets, Marty?
Maybe. I'm open to hearing about it. We're not deciding that now, but it's possible.
I just don't want to be in a situation, Paul, where let's say Michael or another developer, we're talking about potentially knocking down a lot of those existing buildings in time, not today, but in time. And therefore their status of lawful pre-existing non-conforming goes away, and they're subject to harsher conditions than what would otherwise be the case.
But Adam, that was the plan from 1989. It seems to me if you're going to start changing the setback standards in Chestnut Street, you're going to start changing the FARs, you're going to start changing those kinds of parameters.
Hold on, Lee. That's not true. That's not true, because we're dealing with properties that might have been the policy. We're ultimately looking to improve the commercial zoning structure in time, and
It's going to take a long time, Adam.
not necessarily. We
But
could.
I think it should be studied and done in a comprehensive way and not just,
I completely agree. That's why I think what we're doing tonight is all wrong. I think it needs to be done in a comprehensive manner, and this is being done just like that.
this,
I think
this,
that's comprehensive.
Well, if I might suggest that our choices here on this zoning amendment are to say that there shall be a 0 setback or 10-foot setback as we have it, or something in between.
To apply to every.
Because the zoning bylaw, it's not an ambiguity as I read it, having my attention focused on this. It's not an ambiguity where prior interpretations come into play on what the requirement is. It's a mistake. It's an error. And we have to recognize it and we have to address it. Now, Marty, if you want to address it by saying there shall be a minimum front back of 0 feet, we can discuss that.
Well, let's discuss it, because the way it is now proposed, you're given the better position to the person whose contractors who worked for him made a mistake and led to all this. I don't see why that should happen. If you want to allow a 0 frontage requirement for all other properties likely situated in the same way, make theirs 0 also. That's the only way that makes sense to me. I don't understand why we would favor Mr. Tadoldi in this situation, who I think he's a nice person. He's a good citizen of the town. I understand the mistake was made. But it wasn't made by anybody but him. Why have that result in an advantageous position for him? I don't get it. That's my position anyway.
So we have various
George, do
options.
you have any comment to that?
Who are you asking?
Looking at him,
I'm asking George.
On which part of it?
Well,
All of it.
So I guess, so on the one hand, I do understand and don't entirely disagree with Marty's point about, it does, to the extent that you're changing it now that it's been discovered, it does advantage one particular owner. And you're essentially, even though it's not a loophole, you're essentially closing the door on this issue. That said, my research showed that this whole issue came up in 1989. Prior to 1989, the bylaw was clear. It was a 10-foot setback. In this area, it was a 10-foot front yard setback. So then in 1989, or actually 1990, when they changed the bylaw, and essentially they botched, I think, the writing of the bylaw, they probably did not intend this result, but this is what happened. So from there forward, basically since 1990, the bylaw has actually said something different. But we really, there's only been, I think, 2 new buildings, actually even 1 new building in the Chestnut Street Business District that sort of bumped up against this requirement in any meaningful way. And that's the building, that's the medical building at the corner of Chestnut and Junction. And I was not involved in that, so I can't speak to any of that, whether it would have made a difference to them or not. But other than that building, this issue has never been, to my knowledge, looked at really or come up. I mean, this is really only the second building in the district since 1989 that triggered, a look at the front yard setback requirement on the streets other than Chestnut Street. So I'm not so sure, even though I think you're right that that by sort of changing it or correcting the error works out to the advantage of one person. It's also not like it was a widely known, understood, or publicized issue that people would have anticipated, I think.
or intended.
Right. So I'm not so sure. I think it's sort of, it's an unintended consequence that only one person would get advantage by it. But I just don't think, if you ask those owners now that this has sort of come up, they might jump up and say, hey, wait a minute, what about me? But certainly up until this got a big, huge spotlight put on it, they would not have been aware of this. And they probably would have thought that it was a 10-foot front yard setback. I mean, heck, even when we did the original permitting on this project, even I thought it was a 10-foot setback because, I sort of glossed over and went with sort of the policy rather than actually looking at the strict letter of the bylaw.
So I think if I'm hearing everybody correctly, Marty is ultimately looking for an equal practice, a consistency applied across the board. And we're trying to figure out some kind of a solution on a go-forward basis. On the interim, yes, it's true, Marty, the fact set is the applicant's land surveyor, missed this. And that it wasn't an ordinary miss that you would typically expect, because I think it took a considerable amount of effort. It was something, there was some change that had not been properly, I think, promulgated. And otherwise it would have come up in an ordinary legal research or ordinary title search, and it didn't. So there is definitely a problem. We've accommodated a solution for now. On a go-forward basis, I would propose, Mr. Chair, that we refer this zoning to the select board for their comments and questions. and consideration, and then we'll obviously refer it back. And between now and then, we may have an opportunity, to reconfigure this. I ultimately agree that, and I believe that we are due to right size our zoning in the commercial district along, the downtown and perhaps Chapel and Chestnut Street. And that you're right, absolutely right, Marty, that we do that in a thoughtful, intentional way with serious thought. That's a process that we'd undergo in time. And we may revisit at that time this particular section and revise it even further at a later date. But for now, I think what we're talking about is closing a loophole that has been discovered by this, and we move forward. So therefore, Mr. Chair, I move that we refer this to this as written to the select board.
Dave Roach has his hand raised. So before we get to your motion, I'd like to hear what Dave
Sure.
would like to say. Dave?
Yeah, thank you. So just point of clarification, again, this building doesn't sit at a 0 setback. This building sits, and George can verify that, I believe it's 7 feet. I believe a good compromise for these side streets may be a 5-foot setback. This is not the same as the main street. This is not the same as Chestnut Street. These are side streets that have different kind of businesses. I don't believe, and I'll go through the book and check them, but I don't think there's any existing buildings in the Chestnut Street Business District that's not on Chestnut Street that doesn't have at least a 10-foot setback. So I don't see where this is really compromising these people's rights. And in some cases, if you decided to possibly go to a 5-foot setback, that it actually gives them more of an opportunity to expand their property. I only throw that out there, but I want to double check with George, if he can jump back on for a second, what he believes the existing setback of that building on Oak Street is now.
Yeah, so the setback is at the closest corner. It's 8 foot to the building itself, and it's 5 feet to the overhang. And then the other corner gets a little further away, and it's actually 10 feet to the building, and seven something, I think, to the overhang. So it's at the closest point, it's 5 feet, and that's to the overhang. The building itself at the closest point is 8 feet.
Correct. So again, I think 5 foot would be a nice compromise here. I don't think, and I get where you're coming from, Marty. Believe me, this was not a decision that I made lightly.
I'm sure that's true. I totally believe that. Yeah.
Yep. And but it is what it is. We need to move forward. And at some point, yes, you're right. All these other businesses, hopefully sometime in the rest of the Chestnut Street Business District will get redeveloped, and they can take advantage of that setback. But again, it's not the downtown. It's not the main street where we like to see the sidewalk right up against the front of the building. These type of businesses that are in this district right now as they exist, maybe not, orientated to walk up traffic like it would be in the center of town.
No, I get it. But that's the kind of considered discussion we need to have. I'm not necessarily against that. I just want some consistency. I don't want one person to get a better outcome than everybody else. I want everybody to be treated the same way. And Bates and Lee, I must say, maybe it's time, since 1989, whatever the plan was, maybe it's time after 32 years to reconsider the plan,
Well, I don't disagree that, well, actually, this plan was reconsidered when the overlay was created back in 2007. But I think it should be done in the context of looking at the district as a whole and what the goals are for the district.
And I agree with this. I think this opens up the opportunity to review this, but I think I think I have to agree with Dave and Adam and Jean that I think it should move forward for this particular project because of the issues that we just talked about. And Marty, I know that you're trying to say, I know what you're trying to say, that one project shouldn't get it, but I think there was some negligence in the surveying, but there was also some question about how this was rewritten and amended. So I think that it opens up an opportunity for us to look at it. But I think, so I don't think we're necessarily giving them something, very specific to the project. I think it shows that there's some inconsistencies with the bylaws that need to be repaired.
And I want to say that although I appreciate Dave Roach's comment that perhaps a compromise is 5 feet. We already have a provision in our bylaw if property owners proceed under the Chestnut Street Overlay District, that they can have a 5-foot setback, whether they're on Chestnut Street or whether they're on a side street. And I'd like to have what's proposed here, and that is continue the 20-foot setback as the basic requirement on Chestnut Street, and have a 10-foot clear statement that the side streets are a 10-foot setback. When we're studying it, as Adam says, we can consider whether we want a 5-foot setback, or even as we have in our downtown, a 0 setback. But right now, I think this is what we should do, is what's proposed. And I believe that the motion that Adam started to make was to refer it to the planning board, to the select board, the proposed amendment that is in front of us with the slight changes with capitalization of business district and insertion of the words "the." And so I renew that motion.
And we do have time, Marty, because all that we're doing right now is the procedural aspect of sending it to the select board, who then has to send it back to us. We then schedule a public hearing, and we will have, in the meantime, we'll have planning board meetings that we can discuss it, and we'll have a public hearing where we can make an amendment to it.
I do want to call out specifically, Lee, that that when we give notice, that we should send apologize for the crackling. We should send specific notice by mail to these property owners
Who are directly affected,
Marsh,
all the property owners.
Chestnut Place, Freeman, Keith, Oak. I don't know if I think Maple Place, Maple Terrace, maybe, that are affected by that. Marty raises a very good, valid point in that regard.
Happens once in a while.
What's that?
It happens once in a while.
So we have a motion on the floor that I'm going to say was made by Jean.
Yes, that's fine with me.
To
So moved.
send this zoning amendment with the minor changes that we discussed earlier about the business district to the select board in accordance with the zoning statute procedure. And do I have a second to that motion?
I
Second.
second it.
Okay.
Unless Adam really wants to.
No, Natasha.
Question and discussion, which
Sure.
is, assuming we send the draft that we got this afternoon to the
Yep.
select board, and it comes back to us, and there are some proposed amendments, do we have a clear idea and understanding of what kind of amendments we could adopt after it comes back to us from the select board, and which we cannot?
I believe, Lee, that we cannot make it more restrictive, but we can make it more expansive. And so I don't think that we could make the setback greater than 10 feet, but we can make the setback less than 10 feet.
That's right. That's my understanding.
Okay.
Any further discussion? So let's have a vote. Natasha Espada. I think,
Aye.
thank you. Jean McKnight,
Aye.
Adam Block,
Aye.
Marty Jacobs,
Aye.
and the chair votes aye. So it's unanimous. It's going to the select board. We're now more than 15 minutes late getting to the hearing, the public hearing on the, let me make sure that there's nothing else on the agenda.
Mr. Chair, the third item on our agenda is the Board of Appeals.
We can hold off on that until
Bill.
later.
Okay.
Unless, very quickly on the Board of Appeals, does anybody have a comment on the Board of Appeals issue? Because if there's no comment, we can just dispense with it.
I
No
move,
comment from me.
Mr. Mr. Chair, I move that we have no comment to the Board of Appeals on this.
Okay. Any further discussion? Let's have a vote. Natasha Espada,
Aye.
Jean McKnight,
Aye.
Adam Block,
Aye.
Marty Jacobs.
Aye.
And the chair votes aye. Very good. Taking care of that. Okay, so we are up to the 7:30 public hearing on the amended zoning bylaw for outdoor seating. This is a public hearing on a proposed bylaw amendment, which has been sent to the select board, sent back to us, and now we're at the public hearing stage. I believe it's fairly straightforward to change the outdoor seating bylaw to reflect the changes that were made because of COVID that we have all found to be workable changes. This is open to the public. Is there anybody here among the attendees who would like to comment on this zoning amendment regarding outdoor seating at restaurants?
Mr. Chair, do we need to waive a reading of the legal notice? Do we need a motion to do that?
I think that's a good idea.
I move that we waive the reading of the notice.
Second.
for this item.
Okay, Adam made the motion and Marty Jacobs seconded. Any discussion? Hearing none. Natasha Espada,
Aye.
Jean McKnight,
Aye.
Adam Block,
Aye.
Marty Jacobs,
Aye.
and the chair votes aye. And again, I'm not seeing anybody raising their hand among the attendees to discuss this. I'll give it 10 more seconds. Okay, so what's the next motion, Lee, to send this to town, to the select board to put on the warrant for the next town meeting? Lee, you're muted. Lee, you're still muted.
Muted.
Sorry about that. I just want to bring up one issue that was part of this draft that I just want you to consider before we actually close the hearing and then maybe at the next meeting vote to finalize the language. And that is that this has really been written to basically allow for eat-in restaurants. And so I guess I raised the question, I don't, about takeout facilities that have no seats. I just want to think about whether or not we want to include those entities in this relief we're providing. Currently is written for, you have to have a seat in your facility in order to qualify for this expedited process. But if you just had a solely takeout facility with no seats inside it, whether or not you want to facilitate any outdoor seats for that kind of a facility.
What would be an example of an existing establishment that might seek such relief? Even Abbott's has a bench inside.
How about the new Indian place down Chestnut? Sweet Tomatoes. It's an Indian restaurant there. I don't think they have any indoor seats. It's the only one I can think of.
Does Dragon Chef, we do takeout from them, but I don't know if they have indoor seats either, actually.
I know they have I've done food there, and I don't know if they've got stools. I believe they've got a counter, that if they had stools, you could sit at the counter. I don't know whether that would count.
That would count as seats.
Yeah.
I just raised it, I raised it as an issue. I just want to get it on the record in the hearing, and we can, when we take up the final language of it, we can consider it. And I just wanted you to think about that, but I just wanted to get it out there on the table.
Well,
Okay.
this is the hearing. I suppose it's time to discuss it.
Okay,
You know, the takeout restaurants have operated without any seating whatsoever. That's their mode of operation. I'm trying to think, for example, Abbott's was mentioned. I don't really think the bench that people can sit and wait, you know, for their turn is really the bench that's inside. They do have a couple of seats on the sidewalk, actually, right outside their establishment, I believe. No, you
Well,
think
I
they
mean,
don't?
I don't think those are official seats. And
Yeah, I think they're not too. Yeah. So, you know, I'm kind of torn about it. I can imagine a place like Abbott's wanting to enable people to sit and enjoy an ice cream treat.
Yeah.
And maybe the same thing
But
for.
does that- wait. Does that mean that Abbott's can put up Jersey barriers and put tables in the middle of the street like Sweet Basil does? I'm
Only
not
if the
sure that's,
select board
I'm not
allows it.
sure that's our intention, but that's what that change would envision.
That's true. Yeah. And it would be up to the select board.
At that, well,
Yeah, that wouldn't be up to us. That's true.
wouldn't be up to us, but well, in our case, it would be up to us, I guess, if it were in the park, if we're in a back parking lot.
Mhm.
which could be, which could be the case with that Indian restaurant that you're talking about, Marty.
No, they're in that little
Plaza.
plaza there. I don't think they have any parking. Well, I don't think they have any kind of back area to park at all. They have a common parking lot with the rest of the plaza.
So what if the landlord then made an application to take 2 spaces to allow for outdoor seating?
I don't know.
I mean, I'm certainly open to thinking about it. Lee, did you discuss this at all with Katie or with Kate?
mentioned it to me to bring it up to you, to get a sense of whether or not you wanted to include that kind of a venue and not close the door on them.
I'm certainly open. I think the whole point of this is to find, relief for, the restaurant sector that has struggled. We want to find additional relief where possible for other retailers that have also struggled.
let me short circuit this so that we can get to 1688. What I'm hearing is that all that we need to do tonight is close the public hearing.
That's correct.
And then we can discuss this
At the next meeting.
at future meet. Well, I'm not going to be at the next meeting, but I could probably weigh in on it, I suppose. But we can think about it for the next 2 or 4 weeks. And then when we finalize the language to go to the warrant article, we can take that up. So can I have a motion to close the public hearing?
So moved.
Second.
Before we vote on it, Lee, making that change would be more expansive and therefore it would be allowed.
Yes.
Good. Any further discussion? So we have a motion to close the hearing. Natasha Espada,
Aye.
Gene McKnight,
Aye.
Adam Block,
Aye.
Marty Jacobs,
Aye.
and the chair votes aye. Good, thank you all. Okay, we can get to 1688 Central Avenue.
Mr. Chair,
Yes, Mr. Block.
at the risk of some grumbling faces, can I ask for a 3-minute break?
You can ask.
Move for a recess for 3
I will
minutes.
take advantage of that myself. Thank you for asking for it. Let's take a short break. And when all five of us are back at our seats, we will, well, let's make it a 3-minute break in case any of the attendees want to also take advantage.
Thank you.
Mr. Chair, and I'm actually going to recuse myself, but I will be back after the
Very good.
1688 project. Thank you.
Yeah. Thank you, Natasha. Okay. So all of the planning board members for this hearing are back. Lee, you are here. Alex, I can't see your face, so just verify for me that you are here.
I'm here.
Thank you. There are participants, panelists here who I'm not seeing. I guess actually I'm seeing everybody except Pat Day. Pat Day, are you here?
I'm here.
Good, okay. So I guess everybody's here. I have, in my list of panelists, I include Mark Lusing. I have not seen him. Evans, is Mark going to be here?
No.
Okay, thank you. So I am opening the continued public hearing that was scheduled for 7:45. It's now a little after 8 o'clock for the major project site plan of petitioner of Needham Enterprises LLC with regard to the property located at 1688 Central Avenue regarding a proposal to construct a new child care facility of 9,966 square feet. I understand that number has changed, and 30 parking spaces that would house an existing Needham child care business. I do not believe, Lee, please verify for me. I do not believe that there's a public notice here that needs to be waived for the reading.
No, we've already waived it and read it.
Yep, we're all set there. So the panelists that I have listed, so please verify your presence. I have Pat Day, the operator of Needham Children's Center.
I'm here.
Thank you. Evans Huber, the attorney for the applicant.
Present.
John Glossa of Glossa Engineering.
Here.
John Gillen of Gillen Associates.
Gillen, I'm here.
Okay. And John Diaz of GPI.
Yep, here.
Great. So we're all here. So at the last hearing, I had set out some ground rules. And I'm going to change the ground rules. One of the ground rules that I had was a hard stop at 10:30. I'm going to try to adhere to that tonight. We're a little bit late getting started, so we may go a little bit over that, but I certainly don't want to go any later than 10:45. I had set out a ground rule before that I was not going to allow attendees to speak until after everything had been done. I am changing that because I think we have so many issues that we'll be discussing tonight that are separate from each other that I've decided that it would be better practice to allow the attendees to give their opinion on the particular issue in front of us at that point, to have questions answered and to have discussion on those issues. I'm thinking especially because, assuming that we get to the traffic issues, which I believe we will, the attendees will have questions, and if we can dispose of it so that the traffic engineers don't have to come back, that would be a good thing. If we waited till the end, they would definitely have to come back to the next hearing. I also stated that I didn't want to discuss ethics issues, but we're going to get started by discussing the ethics issues that have been raised. So I believe that those are the revised ground rules, the revisions to the ground rules. So let me start with mentioning that there are some additions to the record, to the documents that are in the record that I want to point out for tonight. first and foremost, something that was just added late this afternoon. We have exhibits received for 1688 Central Avenue, received between March 1, 2021 and September 2, 2021. Our staff has put together a total list of 99 items that are in the packet. 7 pages long, but it is a good reference. I pointed out that this document is now in the packet that's available on the website. Might be good for people to be able to look at it and see what's been submitted. All of the letters that we've received, all of the emails that we've received, all of the plans. It's a good index. Yes, Adam.
Can I ask either
Yeah.
Al,
It sounds like there's 3 venues that we have to make sure understand
I'm sorry, who's speaking?
who's vaccinated and whatnot. Us at the reserve side of Messick too.
Whoever's speaking, I'm not understanding what you're saying. And okay, Adam, go ahead.
I wonder, I think it's a good time actually, if either Lee or Alex could give us the website address where these materials exist. Just given the nature of the 7-page document, it might be a little hard to find.
Well, if you go to needhamma.gov
Yeah,
and look for agendas and materials, it's called, I think, you can.
right. Planning board agenda packets. But is there a specific site?
No, it's been added to that packet.
Okay.
Okay, this is not a separate document. It's been added to the packet. Yes, Jean.
If you look at your emails, you'll see it was emailed to you this afternoon.
Well, that's to the 5 of us. I don't, to all the attendees who may want to
Yeah.
look at this.
Yeah,
It's on the website.
it's on the website, right?
Yeah.
I just wanted to be clear on which website. I thought that there was a separate page that contained information
No.
specifically for this project. Okay.
Some other materials.
Paul, this is Alex. Could I say one thing?
Sure.
I just wanted to clarify that any comments that we got after Thursday at noon were not added to the packets per our discussion about the deadline,
Correct.
and they will be added to the next packet. So just wanted anyone who sent comments to know that.
Thank you. So, some other materials that I just want to mention that are in the packets, they're there, but I want to point them out because we have gotten further comments from town boards and agencies. The Public Works Department sent us a letter dated August 12th with comments and recommendations, 4 bullet points. And then there was a subsequent letter dated, I don't have it in front of me, but it was dated, I believe, recently in September, that basically stated that there were no additional comments other than the 4 bullet points from the August 12th letter. We have an email from Tara Gurge at the Public Health Division. I don't see a date on it that has substantial comments, including a comment and a discussion about the environmental testing that had been requested. It basically, with regard to that item, the applicant had satisfied Ms. Gurge that no further testing is required, and they had agreed to do some work on the site to obviate any possible problems, and Mr. Urge was satisfied with that. We also got a memo dated August 13th, 2021 from the Design Review Board with their latest comments. This is very well presented in the sense that there had been a total of three meetings from the Design Review Board. And this August 13th memo has for each item that was discussed, the original Design Review Board comments, the further comments from the second meeting, and then the further comments from the third meeting. So it is very easy to follow what they have done with each of those items. And we have a memo from Evans Huber dated August 4th, setting forth in bullet point fashion the additional changes to the proposed project following the July 20 hearing, which is a good, hopefully is a correct summary of the changes to the plan. We do have an August 9th email from Dennis Condon, the fire chief, saying no additional comments at this time. Other than that, we have gotten additional letters and emails from the neighborhood, and we have received further materials on the traffic studies, and so I'm not going to list those because that's going to be fully discussed tonight. So let me get to the question of the ethical violations that have been alleged. We have been advised that complaints, I assume it's in the plural because there were two parties, the applicant and Mr. Glusing. Complaints have been made with the state ethics commission. And so just last week, town council Chris Heap sent a more detailed letter to the state ethics commission requesting guidance on what this board can and cannot do in terms of postponing hearings or whatever. Mr. Heap's letter is in the package, in the packet that's on the website. I am going to open it up to the planning board, to the entire board, as to whether they wish to consider continuing tonight's hearing to wait for a response from the State Ethics Commission, or if they are willing to proceed so that we get materials in front of us and have the information in front of us as we go along. And also a question of whether we want to ask for the town to hire an independent counsel, an expert on ethics law, to advise us on what we can and cannot do. Mr. Huber, I'm going to wait to call on you to let members of the planning board speak first. Would anybody on the planning board like to speak to this? Adam?
So I have a few thoughts on the question of ethics. I am somewhat familiar with the suggestion that some violations of the state ethics law may have occurred. I'm not convinced myself that in fact a legal violation has occurred. However, I'm not an expert. And the people that have alleged, who have raised these concerns, certainly have a legitimate right and a valid, and their voice is valid. in the process, as is everybody else's. I can understand the appearance. It's a challenge. Ordinarily here, we would simply have a local developer who hired a local architect because the local architect happens to be a good architect who does work in residential and who has a good professional reputation. Unfortunately, in this circumstance, it's not just any ordinary developer. It is a member of the select board. And it's not just any architect. The architect so engaged happens to be on the design review board. And both of those individuals are chair of their own boards. And it's been suggested that the design review board, the select board has oversight to a degree on the composition of the design review board. And I would like to think that it's absolutely ridiculous that one is in the pocket of the other. We've all been through these kinds of vicious personal attacks before, and I just cannot see that happening. However, the truth is, we don't know if a violation exists and what that impact may have. So I think that we want to avoid a circumstance where, with all due respect, Mr. Evans, to your client, we don't want a decision to be rendered by default because of an internal process that prolongs the hearing to a point where a default judgment is effectively entered in favor to your client without regard to any comments that members of the town, in particular this planning board, may otherwise wish to suggest or impose as restrictions or limitations on the development. We want to avoid that circumstance. On that basis, on the basis that we don't know the validity of any of these ethics claims, I would propose that we continue with the hearing tonight on the merits of the application, and that we do have an independent counsel who specializes in ethics law advise us on what the scope of our authority is with respect to this, this circumstance. But if the rest of the board is satisfied based on the leader case and other, and this reading of the state statute, then perhaps that latter part's not required. I apologize.
Okay. Jean or Marty, do you have any comments that you'd like to make?
I'm satisfied that with the research that's been done by Town Council Christopher Heap, pointing out that the planning board under General Laws, Chapter 268A, Section 21, may request rescission of its prior action after a finding by the Ethics Commission. I don't know how long it might take the Ethics Commission to respond to the complaint that's been filed with the commission, but I want to proceed with this hearing, and if it needs to be continued because substantive issues are raised with whatever the continued date is, and then close the hearing. And, if there is no decision by the Ethics Commission at the time of our vote to either grant or deny the site plan approval, take that vote. And then if there is after that time a a decision by the Ethics Commission will evaluate it. It may be at that time, we will need more specialized legal advice. But at the moment, I'm inclined to go forward with the hearing along, that path.
What about the suggestion that we ask the town to hire, and I say ask the town because it would come out of the general budget. Hire an independent counsel to advise us. I reread the leader case prior to this. I reread it this afternoon. And I do think that there's a distinction in the leader case to where we are. So in the statute 268A section 21, and in the leader case, and then there's also an unreported appeals court case that actually had like half a page that was published somewhere, and I was able to get it online, but it's not actually in the bound volumes. But in both of those cases, and I think is contemplated by the statute, a decision had been rendered by the town board. And so the question was one of whether it was ripe to request a rescission or to get a rescission. In the leader case, they were seeking an injunction to prevent the board from enforcing its decision or going forward with its decision. And the court found that it wasn't right because pursuant to the statute, you had to have the finding under the finding of an ethics violation by the State Ethics Commission first before you can rescind the decision. We don't have a decision yet. So those cases aren't directly on point in the sense of we're still in the hearing process. So those cases aren't exactly directly on point in that what's being sought by the neighbors who have requested relief here is that we cease proceeding with the hearing until such time as an ethics decision is made. Adam raises a good point that I do want to point out to the neighbors, which is that if we continue the hearings, we don't go forward pursuant to the zoning statute, and I believe this is a gray area. I don't know that this is definitely the case, but we run this risk that the pursuant to the statute, it may be that because too much time has passed, the relief requested by the applicant as presented by the applicant is deemed given, which removes our ability to put further regulation onto the further conditions onto this project. I don't think that's a remedy that the neighbors would want to risk happening in this case. So I'm inclined to go forward with the hearing, and then when we're ready to close the hearing, see whether we've heard from the State Ethics Commission, and if the board would like to ask for the hiring of an independent counsel, we can certainly go forward with that, but I think we should have that vote tonight so that if we do go forward with an independent counsel, that person can get started. We'd have to find one first, but that's my thoughts on it. Marty, you have any
Well,
thoughts?
I'm in the same place you and Gene are, but I'm not sure that I would seek to hire independent counsel now. So I guess to that extent, I'm where Gene is on that. I think that piece can wait.
Okay.
But I'm prepared to go forward tonight.
Okay, so I think there's some consensus. I do, as I stated, I do want to give the attendees the ability to comment here. I haven't looked to see whether any hands have been raised. I do see 3 people with hands raised. Yes, Mr. Huber, I will recognize you before I open it up to the attendees. Go ahead.
Thank you. So it sounds to me like a majority or perhaps all 4 of the board members are in favor of moving forward tonight, which is obviously my primary goal. I would just like to state for the record that I believe Mr. Heap, Town Council, has already notified this board that in his view, he wrote an email back on July 14th, or July 16th, I'm sorry, in which he says, and among other things, this is an email to you, Mr. Alpert,
Yes.
but was also shared with other people, including, I believe, some of the neighbors. As previously discussed, I don't believe that Ms. Abrazese's arguments relative to the state ethics law provide a basis for the board to stop or postpone its hearing on a zoning application. But again, this is not a subject that the Ethics Commission will offer an opinion on. I'm aware that Mr. Heap has recently sent a letter to the Ethics Commission, asking for an opinion that he had previously been told they were not going to give. My view of this is that it is not appropriate. Well, not only has the board already received an opinion from qualified counsel that it has no basis to stop the hearing on the basis of this request or allegation, but I also find it inappropriate, to say the least, that the people who are opposed to this project would continue to insist on the validity of their position and continue to ask the board to stop their proceedings after the board has already inquired of town council and received the letter or email reply that they got. I'm sure that the board would not appreciate it if you ruled against my client on this matter or that. And I continue to ask you to change your mind. It's just, in order for this to move forward in anything resembling an orderly fashion, issues get raised, the board makes a decision, it seeks opinion from town council where appropriate, and then we move on. And I think that's what should happen here.
I'm just going to comment that original email and the telephone call that Mr. Heap made to the State Ethics Commission was prior to it being public knowledge that a formal complaint had in fact been filed with the State Ethics Commission. And in my mind, pointing out to the State Ethics Commission that we are all aware that a formal complaint has been filed may change the answer that we get from the State Ethics Commission. I think the State Ethics Commission was rightfully reluctant to admit or deny whether or not there was a matter actually in front of them. But this letter starts out with, we all now know that there is a complaint in front of you, and so we're asking again for your guidance. To be honest, on my opinion, I don't expect to get an answer from the State Ethics Commission in short order. If we get an answer at all, I think it's going to take quite a while, and that's why I would like to go forward. And I think you've got that.
Okay, thank you.
May I ask you, Paul,
Sure.
on the question of hiring special counsel, and as chair, who might have a special reason for wanting this guidance, do you particularly wish that we would vote to do that?
No, I didn't want to
Thank
make
you.
that decision myself. I wanted to have the input from the full board. I mean, when I say the full board, of course, Natasha has recused herself. I didn't want to dismiss that out of hand. I'm somewhat confident in my ability to read the law. I'm confident in Mr. Heap's ability to read the law. Neither one of us are ethics specialists.
Mhm.
So that's the question as to whether we should get a specialist. You know, I don't think it's necessary personally, but it's certainly something that if the three of you wanted to go forward with it now, you know, I'd be fine with it. But it sounds like none of us really, or at least three of the four of us, are ready to proceed without going that route. And if as we go down the road we decide that we need it, we could probably get somebody who could give us an answer in a fairly short period of time.
Okay, good. I'm comfortable with that. Yep.
Okay. So we do have, I do see two hands raised. Alex, if you want to, on my list of the attendees, I don't know if this is in order chronologically, but I see Dave Lazarus first and then Maggie Bruce says a second. Dave Lazarus just dropped off. Oh no, because he's now with us. Dave, welcome. Please take yourself off mute.
Thank you very much. Bear with me for one. There we go. Coming to you live from my basement on Oxbow Road. Good evening, everybody. First of all, before I get into the substance of this, I just want to thank Mr. Alpert, thank the board. You know, this is clearly a very complicated issue that's before the board. I've sat through a lot of meetings now, and it is clear that while I think we may disagree on a lot of the substance in some what I would consider important ways, you know, having the opportunity to speak, having you revisit your thought on whether or not to let the community participate in each step of your decision-making process, these are all important things. And I'm not speaking for anybody but myself, but I recognize that everybody is trying to do what they think is the right thing. And I really appreciate that. And so that's the spirit with which I make my comments tonight. I just want to, you know, as far as the ethics issue goes, one last thing before I move on to that, I just was looking at the index while other people were speaking, and whoever put that together, that was clearly a ton of work. And it's a really great document to have. So thank you for that as well. And so as far as the ethics issues, and I want to speak later at the appropriate time about the traffic and safety concerns, but the ethics issues, this is an incredibly serious issue. And it is not a matter of whether somebody who happens to work in the town is also volunteering. Everybody has a right to make a living. Everybody has a right to volunteer and run for office and give up their time and serve our community. And those two things don't have to be mutually exclusive, but anybody who does choose to participate, as everybody on the board knows, has to do so within the confines of the law. And so Miss Abrazazi is prepared, I think, to address a lot of the substance of the ethical violations that we or that I have seen and that I believe a complaint has been made about. But in sum, it's a matter of the chair of the select board is not allowed to represent another person before this board, period, full stop. He can do other things to make a living. He can be a real estate developer, but he's not allowed to apply for a permit on behalf of someone else, either Needham Enterprises or Mrs. Day. And that's what's happening here. Then on the other hand, Mr. Glusing, who I'm sure is a wonderful architect, and nobody is disputing or making any of this personalized to these individuals. They're trying to do what they think is right. We disagree, and we think that there's ethical problems here. Mr. Glusing, when he appeared before the planning board at one of the prior hearings, he was vouching for the planning board about what a design review board would and would not consider normal and would be doing. And he's the chair of the design review board, who's essentially conflicted off of that, who's also advising this board on the duties of that board. And so the overlap is ethically very troubling. The optics of it are very frightening as a taxpayer. And so the board obviously has a duty to the town and to the citizens. I understand there are several attorneys on the board. The board has clearly demonstrated it's a group of very smart, competent people, but that's not the issue. Essentially, the board is electing to go pro se in this matter and to address issues outside of their own specialty and their expertise, when all the board seemingly has to do is request the town approve a specialist to come in and advise the board. The harm of the board not choosing to do so is drastic. The property will be leveled, a building may start, that if ultimately there is an ethical violation which is found, which the community, the neighbors and the abutters have indicated that they think is possible. If the community were to ask this board to rescind the permit at a later time after the project has started, it could be disastrous. There could either be, a best case in that scenario would be a project that's completed. Worst case is a project that's halfway done and a permit gets pulled, and now we've got an eyesore and a danger to the kids in all different ways in the community. So the harm to the community of choosing to continue without an expert opinion about the ethical pitfalls here is very significant. And the harm for the developer for waiting is not as significant. Winter is coming. It is, I'm not an expert in construction. I would consult an expert on this, but it is doubtful that this property is going to be built in the next few weeks before winter is here. I don't know what happens over the winter. I have no idea, but the delay necessary to at least let Mr. Heap get the expertise that he's requested is small. And it's the delays so far, I think it's really important to keep in mind, have been all at the request of the proponent. The developer has asked for every break. This board has not said to the developer, we're stopping, you have to do this, you have to do that. The developer has asked for the board to take the pauses that it has taken. So it is not as though this board has kept this project lingering. And I'm almost done and I'll stop. And again, I really appreciate the opportunity to speak. There's an actual conflict here that is hurting the town. Even if there's not an actual conflict here, even if I'm wrong, even if there's no conflict, this is now a public issue in the town where the town is looking to the board to see what its elected officials are going to do. And for the board to say we could ask to hire a lawyer, but we're not going to, simply because we think we're right, is a tough thing for the town to swallow. All that is required is to get an expert to come in. That's all that we're asking. Take the time to do this right, please. The harm of continuing is really irreparable to us. And so I would just urge you to, for somebody to make a motion to ask the town to authorize independent counsel, and for the board to pass that and to get independent counsel. Even if you continue with the hearing tonight and don't take action, you hold it open, you can do both of those things. But getting counsel, getting somebody to advise the town and the members of this town on what is actually happening and what should happen is critically important. And with that, I'll yield back. And again, thank you everybody for what you do for the town and for letting us participate tonight.
Right. David, first of all, thank you for your kind words that you started with. We appreciate those comments. And our staff did work hard to put together that list of documents, and we greatly appreciate it. Well, first of all, the delays were not always at the request of the developer. The August hearing was delayed by the board's initiative because materials were submitted so late that the board, I believe, I'm not even believing, but guessing to the applicant's chagrin, decided to postpone the August hearing to tonight. So I wanted to clear that up. I don't think we're going forward the way we are because we're convinced that we're right. Maybe I am convinced that the board really doesn't have a place in the ethics debate, which I understand that the neighbors disagree with that. But we have asked the State Ethics Commission. We may or may not get an answer from them. And if, their answer may obviate the need for an independent opinion. I think we would need to get an independent opinion if we didn't hear from the State Ethics Commission by the time we were ready to close the hearing. Those are my answers to the issues that Mr. Lazarus just raised. Yes, Adam. You're on mute, Adam.
Thank you. Sorry about that. So, Evans, I'd like to ask you the question directly. If I understand correctly, what Mr. Lazarus has suggested is that by law, the chair of the select board is not lawfully allowed to represent another party here, the daycare's business, in front of another board, separate for whatever violation, perceived violation that perhaps Mr. Glusing may have had. Just on that issue itself, is it what is your opinion on that question of law?
My opinion is very clearly that on the allegation that because Mr. Borelli is the manager and member of Needham Enterprises LLC, he cannot pursue any development that requires a permit from another board in this town. I simply disagree with that.
But the distinction that's being made is that it's not really a permit necessarily for his direct benefit. It's a permit for a tenant, for a different party. And
The issue is not, the issue, as I understand it, under the applicable law, the issue has to do with the fact that it is not Mr. Borelli who is the applicant. The applicant is Needham Enterprises LLC. And the fact that he is a member or the manager of that does not make him a person acting in his capacity as, or in his status as member of the select board. That's, you know, corporate entities have legal significance, and there is a legal significance in this particular matter to the fact that the applicant here is an LLC, not Mr. Borelli personally. Moreover, as may come up at some point during this hearing, another allegation has been made in this with respect to this issue, which is, you know, whether Mr. Borelli or Needham Enterprises has been paid for this, because that's part of the issues raised by the opponents of this project. And the fact of the matter is that he has not received anything of value. He does not have a lease with the operator of Needham Children's Center. In theory, obviously, we want Needham Children's Center, which we think is an asset to the town, to be the tenant here. But in theory, not in theory, in reality, Needham Children's Center has no legal obligation right now. If they want to pull out and walk away, they can. And so I do not think it is accurate to say that he is, apart from the distinction between him personally and Needham Enterprises LLC, it is not accurate to say that he is doing this as an agent for Needham Children's Center. And so I think for both of those reasons, it is simply incorrect to say that Mr. Borelli is engaged in violations of the state ethics law simply by having a legal connection to Needham Enterprises LLC or being the manager or the member of the LLC. I do not agree that that results in a violation of the state ethics law.
So I agree that courts have made a distinction between a natural entity as an individual and a corporate entity as being two separate beings. I recognize that. I do, as you're saying, wonder if we've opened up another can of worms where in fact now we actually have perhaps no daycare center. We have a developer acting on his own accord to develop a building that theoretically is going to be used as a daycare center. And I mean, by clearly all intent, we see the work that's being done by Pat, and the reason why the engineer has been engaged and the drawings have been drawn up, the civil engineer, the traffic engineer, clearly it seems as though the intent is to have a daycare center, and yet now I wonder to what extent we're actually driven by the Dover Amendment as a protected use if it's no daycare center currently. Does that raise other issues?
The answer to that is very clear and simple. When a special permit is issued here, which I believe it should be, obviously one of the conditions is going to be that it is used as a childcare facility.
Right.
And you know that it probably can't be a condition that it be Pat Day or Needham Children's Center, but it certainly could be a condition as to the various operational features that she has described and that are found in Mr. Gillen's analysis about the number of children and the hours and when the children arrive and leave. So obviously we hope that that's going to work out, but I think the board should be mindful of the fact that right now, Mr. Borelli is doing this at his own risk, so I think that's a very meaningful fact, both in terms of whether or not there's an ethical violation here, but also in terms of his good faith. There's been a lot of allegations here. And, people are saying, well, we think everybody's acting in good faith and we just disagree. People are alleging that Mr. Borelli is violating a criminal statute. That is a serious allegation, and we do not take it lightly.
Can I just ask you a question about that? Because what I heard was you said Mr. Borelli is doing this at his own risk. Shouldn't you have said that his LLC is doing it at its own risk? Isn't that what you meant? Because if he's doing it at his own risk, I think that argues against what you were just saying about
there are two issues going on here. The statute has very specific wording, and if you are trying to allege, as every member of this board who's a lawyer knows, that criminal statutes need to be construed very precisely and narrowly. And the issue with respect to the criminal statute that is being alleged to have been violated is whether or not there is in fact a violation. And that turns on things like whether or not there is a legal distinction to be made between an LLC and the member and manager of this LLC. I believe that there is, for the purpose of interpreting that statute and whether or not there's been a violation. Let's not pretend that we don't know that Mr. Borelli is the member and manager of this LLC. So yes, ultimately, if this project fails, it's going to redound to his detriment. But that does not mean that he is violating the statute or that it is a meaningless distinction between himself and Needham Enterprises LLC for the purpose of determining whether or not there's a statutory violation.
Well, I totally understand that, Evans. But if you're trying to keep some lawful distance between who's the real applicant here, and you tell us that this is all being done at his own risk, not the LLC's, you're certainly blurring the waters. I don't think you want to do that.
Okay, fair enough. I take your point.
Okay. And let me just add, because this is important, actually, to me. we've spent a lot of time hearing from Pat all about the Children's Center. They've been wonderful corporate citizens and for many, many years. I just wanted to be clear to all those people who are telling us this, that I think that all of that is interesting, but misplaced. I don't think this hearing is about the Needham's Children's Center, not because of the distinction that there's no lease signed, but because this is about this site and what's proposed to be done at this site, not what Needham Children's Center has done in the past someplace else, but how this particular property is to be used and how it's going to affect the area and all that. So for those who want to tell us about Needham Children's Center, you know, to some extent, it's up to our chair to allow that, but to me, it doesn't really matter. I just want everybody to understand that.
Well, okay, and I guess I would respond to that by saying, again, clearly, if and when a special permit is issued in this case, it is going to include a number of conditions, one of which will be that that this building is used for a child care facility.
Right.
And so we are designing it with Needham Children's Center, as you know, in cooperation with them, with their input, with their desires and their schedule and the kind of environment they want to provide for their children. We certainly hope and intend that they will be the occupant, but I agree with you technically, you know, right now before you, the applicant is Needham Enterprises, and we are seeking approval for a building that is going to be used as a child care facility.
I completely get it, but I think it's very much more than a technical point, because whether or not Needham Children's Center is your first tenant, they could sell the business a year later. There's nothing at all that we could do about it. There's nothing at all that the planning board would have the authority to say about it in advance or at the time. So we cannot proceed. We never proceed as if only one particular person or company is going to use a particular place. We just don't do that.
No, I understand that.
So, but I know you do, but I think there's a lot of people probably listening in who don't appreciate that difference. But I just wanted, for their purposes, I wanted to make sure that they get it. So, and this is no criticism of Pat. I mean, I don't know Pat, but she's got a wonderful business. She's got a terrific reputation. It's all great. I just want everybody to know that this isn't really about Pat.
I want to point out, because I've been reading as much as I can of the cases that are involved here, there is at least one case that I've read. I'm stretching my brain as to whether there's more than one, but there's at least one case that I've read where the applicant was the property owner. There was a stipulation of facts that was agreed to by the property owner and the planning board or the zoning board of appeals. I forget which was the permit granting authority in that case. But there was a stipulation of fact that he intended to lease it to a children's center, did not have a tenant yet. And the case proceeded. The case went to the judge to make a decision on the issue that wasn't in front of it, which, you know, had to do with the land use and the zoning bylaws and the 40A Section 3 issues. But in that particular case, there was no specific tenant yet. And the applicant was not going to run a children's center. He was a property owner, like Needham Enterprises. And as I said, that case went to trial and proceeded. So there's some precedent for that.
And we would certainly make that representation or have that be a condition or a stipulated fact, because that is in fact the intent.
Okay, we now have 3 other attendees who wish to speak. Oh my, I'm getting a notice. I forgot to plug in my computer, so I better plug it in before I lose you guys. My power is getting low. I'm plugged in. Maggie Prusezi, I believe, is next. Alex, if you can bring Maggie aboard. Maggie, you're muted. Unmute yourself and you have the floor.
Hi, thank you. I'm Maggie Abruzzi at 30 Bridal Trail. I would like to echo David's thank you to all of you in working on this. I certainly see how many hours and hours you each spend doing the business of the planning board. And I really appreciate all that time and that effort. I would like to, in addressing the ethics issues, I would like to take a step back for a moment and just remember that this started more than a year ago. Selectman Matt Borelli personally reached out to the Director of Planning, Lee Newman, by email. And he said, "Hi, Lee, I have a client interested in starting a childcare facility at 1688 Central Avenue with me as developer." That was the beginning of this case. Selectman Borelli wanted to know how he could get town approvals to build this childcare center for his client. As developer today, Selectman Borelli is arguing that Needham's zoning bylaws are invalid. He has said more than once to this board, you can't inquire about this particular thing, or you can't impose a particular restriction here or there under the bylaws because of the Dover Amendment. He's arguing that the interests of his daycare client in building the building as proposed outweigh the legitimate municipal interests of Needham that the zoning bylaws seek to protect. In other words, where the interests of Needham and his client conflict, Selectman Borelli argues that his client and not Needham should prevail. This is a conflict of interest, and there are at least 3 different ethics laws that make what he is doing here illegal. And I do not say that lightly. I absolutely would not make such a serious allegation lightly. I have given full briefs on the law and the facts that make this so. When we talk about Mr. Glusing, Mr. Glusing is chair of the Design Review Board. The Design Review Board is responsible for reviewing the project and giving input to this board. The DRB has reviewed this project, including Mark Glusing's own architectural drawings, and has expressed some concerns with the design. Mark Glusing stood before you last hearing and advocated that you should accept his designs as is. He took a position that is in direct conflict with what his own board recommended. This is a conflict of interest. Mr. Glusing is pursuing the private interests of his client instead of the municipal interests of Needham. Ethics laws were created to prevent this situation. The training materials given to every special municipal employee in Needham specifically talk about how it is illegal to allow professional documents prepared by you to be submitted to your own board or to any board in connection with matters that are before your own board. They specifically talk about not being paid to give a developer advice about how to get a project approved by your own board. They specifically talk about how you can't appear before the planning board if the matter involves something that is under consideration of your own board. I recognize that this planning board, you're not specialists in ethics laws. You can't litigate these issues, and you can't determine the legality of what Selectman Borelli and DRB Chair Glusing are doing here. And I'm not asking you to litigate it. I'm not asking you to make that determination. What I'm asking you to do is to pause, to seek legal counsel, and make sure that everything is proper before you proceed. There are legitimate questions here raised about whether it's legal for Mr. Glusing to submit his architectural drawings to this board in support of Needham Enterprises application, about whether it is legal for Mr. Glusing to appear before this board and give testimony in support of Needham Enterprises application, and whether it is legal for Selectman Borelli's company, which is wholly owned and operated by him. He's not just a manager of some huge conglomerate. Mr. Borelli is Needham Enterprises. There is no one else involved in that LLC. So the question is it legal for Mr. Borelli's company to pursue an application for this board's approval? The interests of Needham are best served if this board does not base its decisions on the contents of applications that are submitted in contravention of the law, on architectural drawings that are submitted in contravention of the law, or on testimony that is submitted in contravention of the law. The board should protect the integrity of proceedings before it by insisting that people who file applications or submit supporting materials or give testimony be doing so legally. If the board looks the other way and allows the application to go forward in spite of legitimate questions about conflict of interest, that significantly erodes the public's trust and confidence in the integrity of Needham's government and the proceedings before this board. We are not accusing the planning board members of impropriety here, but you need to recognize that your decision is only going to be as good as the information you based your decision on. If the opinions that you get from various town boards are skewed because of the proponent's position of power over the people who need to give you feedback on the application, then your decision is going to be skewed. Not because you're biased, but simply because the feedback that you receive from the police chief or the fire chief or the town engineer or the health department or town council is given differently because of the fact that they are commenting on the project of someone who is in a position of power over them, someone who votes on their collective bargaining agreements, someone who votes on their department budgets, someone who votes on their facility renovations, someone who votes on whether to put town council's contract out to bid. They are commenting on the project of someone whose support they need. Conflict of interest laws recognize that citizens generally will not personally know each of the people serving in town government. Citizens are not in a position to know the inner thoughts of each municipal employee and whether someone would be improperly influenced by the fact that it is one of the 5 most powerful leaders in the town that is asking for their department or their board's approval or comments. That is why conflict of interest laws outright prohibit municipal employees from making money from town approvals, particularly where the matter involves their own board or boards or departments that the employee oversees. That is why conflict of interest laws prohibit an employee from representing a client's interest in matters in which they should be representing the town of Needham's interests. The case of the Board of Selectmen of Barnstable versus the Alcoholic Beverages Control Commission case that I had sent to you in a prior filing stands for the proposition that municipal boards always have the power to insist on common sense standards of propriety, that they always have the power to protect the integrity of their proceedings. Propriety and common sense dictate that this board should pause what it's doing and make sure that the legitimate ethical questions presented here are answered before it moves forward on the application. This does not mean you have to wait for a resolution of the state ethics complaint. The ethical questions could be resolved expeditiously by Matt Borelli and Mark Glusing themselves. They could exercise their right to get a written opinion from the State Ethics Commission on these questions, and they could submit those opinions to this board. Alternately, the questions could be resolved, as you suggest, by hiring an independent legal counsel who's an expert in ethics to give a full legal written opinion on the ethical questions raised here and on what avenues the board has available to it. I urge you to safeguard the integrity of the proceedings before this planning board by insisting that the ethical questions be answered before you consider the merits of the proponent's application.
Thank you. Thank you for a well-presented argument. Adam, did you have your hand raised?
I did. And Pat, unfortunately, this little fellow is 9 and is past the age of daycare. I wouldn't even know your daycare existed when we moved to town. Maggie, I don't take lightly the comments that you said, clearly, and none of us do. You have presented well here verbally, and the written submissions that you have made are well researched and are persuasive enough to a point that I have articulated my desire to actually have my cake and eat it too. The will of the board may be different, but I think that there may be a middle ground to be able to proceed, not to render our decision immediately, but to at least continue with the merits of the thing while we are outstanding on the question of the scope of our own authority. Not the scope of the planning board, not the scope of the design review board, only the scope of our own. We know we cannot decide a question of law on ethics. We don't have that purview. Our scope is a little different. I have one question for you. You made a comment that the select board chair Borelli emailed Lee, the town director. I don't have a copy of that email in front of me. Did he do that from his select board needham.ma.gov email, or did he do that from a separate email acting in a different capacity?
He did not use the select board email. Am I live? You can hear me? Yes.
Yes. we can hear
Okay,
you.
great. Thank you. He did not use the select board email. He used his personal email address to personally reach out to Lee Newman to ask her how to get this project approved for his client, a childcare center who wanted to build at 1688 Central Avenue.
So you're also insinuating that Matt is in the pockets, that the police chief and the fire chief and these town offices are in the pockets of the select board chair because the select board and he as chair has oversight and direct participation into their negotiations. I think you have some validity in some of the arguments that you've made, but that suggestion, I have to say, I will say it this way, is a distraction away from the substantive elements before us on the development. I do think, again, you've raised valid questions, which is so valid, in fact, that I actually think that we should consider having an expert counsel, special counsel, advise us on the extent of if there are violations and the extent to which those violations are within our own purview. But I do need to draw a line on what I think is inside the scope and what I think is outside the scope. Again, I think your legal research is detailed, and I think and the questions you have raised are valid. And I appreciate you being engaged in the process if nothing else, to teach this little 9-year-old the importance of what civil engagement is all about. And now he's being called to bed. I love you, Monkey.
Paul,
Apologize. But so,
I'm sorry.
Can I just, I understand what you're saying about the ugliness of contemplating that someone's professional work would be affected by who it is asking them to comment on their project. And I am not saying, I know for a fact that so-and-so did such and such because somebody said to, that isn't what I'm saying. What I'm saying is the reason that conflict of interest laws exist is so that no town employee has to make that decision. Do I comment? How much? Every town, in every giving of comment, there's a degree of latitude. You can give no comment, you can give meek and mild comments, you can give strong comments. And I have no way of knowing, and no citizen in Needham has any way of knowing to what degree the position of the person asking for approval of their project has on the way that those comments are given and the whether or not they're given or how they're given. I know if my boss is asking me to comment on something, I think carefully about my response, because why am I going to anger someone who has a lot of control over me? And I'm not saying that that has happened here. What I'm saying is this is why we have conflict of law,
you more
conflict
Maggie, with respect,
statutes.
you've argued more than that. You didn't just do that. You've suggested that you've implied an impropriety here. And I recognize and agree with you that every citizen has a right to, for a duty to expect a proper lawful process is happening.
Yes.
But to think that our public safety officers are going to turn around and just grant the guy, wink, wink, nudge, nudge approval effectively on this kind of thing for a 20% share of a vote on a separate duty is a different issue. That's my own personal comment. I don't, but there
Adam, let me just say, that's why what I hear from Maggie is less than you're suggesting. What I hear from her is perception is important.
I agree.
She says that's why the ethics law are written the way they are. Perception. Can I bounce back to Paul for a second? Paul, can I ask if we can hear from Evans, his response to Maggie's presentation?
You can ask. Evans, you have the floor.
Thank you. So I don't think that we should be sugarcoating what's going on here. I happen to agree with Adam, and I think he's actually being extremely polite. Nobody could have listened to what Ms. Abruzzi, I'm not sure if the correct pronunciation of her last name, said and not hear her strongly imply that various town officials are skewing their opinions and decisions because of the fact that Mr. Borelli is the chair of the select board. And I think that every member of this board would agree with the idea that not only is that not happening, but this board and as is clearly apparent from the comments made by the Design Review Board, are going in the opposite direction. This board has given every accommodation to the people who oppose this project and to listen to their complaints and objections. The Design Review Board has reviewed this project 3 times and given a detailed memo, which has been amended and then amended again with various kinds of comments, many of which are not particularly favorable to this project. To suggest that somehow Mr. Glusing's chairmanship of the DRB has resulted in favorable treatment from the Design Review Board, or that what this board is doing and is contemplating doing and will do when it issues a special permit, if that ever happens, is somehow affected in Mr. Borelli's favor because he is a member of the select board, is to ignore what's actually been happening for the past 6 months since we filed this application. So, you know, there is just no basis. There is no basis whatsoever for the idea that this process has been tainted in Mr. Borelli's favor by the fact that he is a member of the select board. And so a very good job of lawyering, just like, you know, Mr. Junta demonstrated, a very good job of lawyering has been done to find and allege violations by Mr. Glusing of the conflict of interest laws and so forth. But what I would ask this board to do is to step back and look at, you know, Ms. Abruzzese talks about why was the conflict of interest law enacted. The conflict of interest law was enacted, in my view, to prevent people in positions of power and authority in a town from using those positions of power and authority for their personal benefit or for some benefit that is antithetical to the interests of the town. Nobody on this board believes that that is what's happening here. Nobody believes that Mr. Borelli is getting a leg up or getting a more favorable decision or getting a pass on any issue with respect to this project because of his status. So technical violations have been alleged. Maybe the State Ethics Commission will conclude that those are correct, that those violations have been identified. I don't know how that's ultimately going to play out, but I don't think anybody can think that the substance and spirit and intent of the ethics law, which is to prevent somebody who's a member of a town or municipal board in this case, from using that position for their own personal gain, is what's going on here.
Thank you.
Okay, we have 2 other people who have raised their hands. And Matt Heidemann has been going in and out on his hand raise, so he's now behind in the queue. But because he's been up there and going back and forth, I would like to call on Matt Heidemann first before going to the other party that has a hand raised. Matt, you're up and you can unmute yourself. Thank you.
Thank you very much. I appreciate the acknowledgement, Mr. Alpert. I really do. So Mr. Huber and Planning Board, I want to address a couple different things. So my role as a day-to-day citizen and what I provide to this community is I am a business development manager to the public sector of all of our federal government. And for you to sit here and say that holding boards or positions on boards does not give us a leg up in situations for commercial use is an absolute facade. I do this every day for my job. I do this through professional lobbying organizations. I do this through positions that I hold on charitable foundations or 529 organizations. And I do this because it gives me access to the people that control the ability to more or less control the outcome of my project. And for you guys to sit there and say that this is a legal aspect of the way things work, regardless of whoever sent an email to a public official, whether it came from his Gmail address or whether it came from his professional Needham address, I understand, but the implications here are absolutely 100% warranted by what Mrs. Ambrosio said. And I just want you guys to understand that. And I do this at the highest level of our federal government on a day-to-day basis. And I just want that comment on record.
Thank you.
May I ask Mr. Heidemann for his address? I'm not sure we have that yet.
1708 Central Avenue.
Thank you.
Which is the immediate abutter to this on the opposite side of
Thank
the
you.
temple.
Okay. Thank you, Matt. Shannon Buckley, you have your hand raised. You're up. You can unmute yourself and join us. And please give us your address.
Hi, I live on Harris Ave, and I just wanted to talk for us as a staff member at NCC. I think that's kind of been overlooked so far. I have a business degree. I have an education degree. I understand the intricacies of everything that's going on, but I think we're so tied up in like the ethical dilemma that we're kind of forgetting all the other people and ethical situations that are tied up in this decision. I've worked at NCC for almost 7 years, and I just want to say that most of the people watching tonight are the teachers, and we're kind of waiting to see, you know, we know that it's possible that the First Baptist Church is closing. We're trying to find a new location. So a lot of us are wondering, do we have jobs in a year? What are we kind of doing there? I know you're debating a lot about Matt Borelli and all of that. I don't know him. I've never met him. I can't speak to any of that business relationship, but I just wanted to say that a lot of the staff members at NCC are longtime Needham residents. I went to Mitchell, I went to Pollard, I went to Needham High. I've lived in Needham my whole life, and I'm tied to this family, and we're just kind of wondering what our future is here. And I think that that's a big factor that's being overlooked. I understand that it's not necessarily about Needham Children's Center and more about the location, but also where else are we supposed to go? You know, Needham's a jam-packed town. There's tons of businesses. It's thriving. Also, Adam, our after-school program goes up to age 11, 5th grade. So you're invited if you want to sign up. But I just kind of wanted to speak on behalf of the teachers that many of us are Needham residents. Many of us grew up in Needham. We have strong ties to Needham families. And I agree that this kind of ethical debate kind of seems like a personal attack on the developer, whatever, and less about the location and the school. And we're all kind of, you know, the meetings keep getting delayed, and we're all kind of wondering what our future for our jobs are. And, you know, we love our NCC family and none of us want to go anywhere. So if we could still have a home, that would be great.
Thank you. We appreciate your comments. So I don't see any other hands raised. So I think we can close out this issue. So the question is, in my mind, the question is whether what we've heard was enough to change the board's mind about A, proceeding tonight, and B, hiring special counsel to advise us. So, Adam? You're muted, Adam.
I think we continue on the substance. What's the harm in engaging what's the harm to us of engaging a special counsel to advise on the scope of the authority of any appearance of a violation in the process?
Gene and Marty, do you want to respond?
So, go ahead, Gene. I'm sorry.
Yes, it seems to me that the only issue that we would be asking special counsel for advice on is whether when a complaint has been filed with the State Ethics Commission, a planning board must cease acting on an application until that issue is resolved.
I would
And I'm,
modify that, Gene. I'm not sure the word is must. It's must or should.
okay. All right, must or should. I feel comfortable that we can go forward with this hearing. And I don't think we're going, I mean, it's already 9:30 and we have a lot to discuss with regard to the traffic report and the peer review. And I feel certain the hearing will be continued. You know, it's possible that there will be something coming from the State Ethics Commission, but I just don't feel a need for that advice. I feel comfortable about going forward.
Marty?
I would say I think I'm convinced that, number one, we should proceed with this hearing tonight. Keep it moving. And I'm also now convinced that, as Adam seems to be, that why not? Why not go ahead with a special counsel or independent counsel who has expertise in this area? I think we all concede that we don't have that expertise, which is why we've been hoping to get some guidance from the Ethics Commission, but we don't have it. We don't have it yet. So I would be convinced, I changed my mind on that I would go ahead and seek counsel. And I wouldn't necessarily limit that counsel to any particular question. I want advice. What should we do? This is what we have done. What should we do on the ethics front? I would keep it fairly general. That's where I am.
Okay. So we've heard a lot of information. I'm convinced, number one, that there is a remedy in the law here. If the state ethics, one, we should go forward. We should get our facts. We should hear everything we're going to hear, and we're clearly not going to close tonight. I don't even know if we're going to close at the next hearing in October, because there's a lot of information that we need to get, and there's a lot of discussion that we need to have for whatever conditions and what the courts call reasonable regulations we put on this project. There is a remedy, which is that we issue our decision. The State Ethics Commission makes its findings, and if they find that there have been ethics violations, we can ask that the project be rescinded. Now think about that. This is going to take a long time. I think it's going to take a long time for the State Ethics Commission to even reach this, especially during COVID times, and we're still in COVID times. So we could render our decision. The building could get started, the building could be built, and they find, if the State Ethics Commission finds ethical violations, we could ask to rescind our decision. And then there's a building that's there. Mr. Borelli would have spent a lot of money to put that building up. And if our decision is rescinded, and we don't get to rescind our decision, I think the statute is clear that at that point, it's the State Ethics Commission that decides whether to rescind the decision. And if the decision is rescinded, it seems to me that the remedy is that the building comes down.
Or it's also possible that the building be sold.
Well, but sold for what, Adam? Because, you know, they're all, it's still single residence A.
Paul,
Okay.
Unfortunately, we don't know what the remedies are. We're speculating.
Yeah.
And
But
that's reason enough.
But if we say, well, if you can't have a daycare center, building has to come down. Or if you can't find another tenant that is a permissible use for that building, Mr. Borelli would have spent a lot of money to put up and then tear down a building. And
I don't know that I'm not convinced that he would necessarily have to.
So, it's a possibility, but he still might spend a lot of money to put about what winds up being an empty building. Okay, or he has to turn it into one way or the other. I think that's something that he needs to consider. I'm going to lean towards, let's get an opinion from an expert, and let's ask the town manager, because that's who controls the purse strings here.
So on that basis, shall I make a motion? I move therefore that the planning board asks the town manager for a special financial approval for us to engage a special counsel that is in fact a specialist in the matter of ethics law in Massachusetts, state ethics law, and to advise us on the scope of our authority and the extent to which we want a legal opinion on the extent to which we can continue and finalize our process, given the risk that in the event it's delayed by a certain amount of time, that the relief sought by the applicant is by the process of zoning law automatically rendered. And where is the public good in that process? I think that, so.
Adam, is that part of your motion, or is that, are those further thoughts more like discussion?
I appreciate the distinction. I crossed over into an opinion. So the motion is, thank you for clarity. The motion is, I move that we ask the town manager for approval to engage special counsel who is a specialist in state ethics law to advise on the scope of our authority on this particular matter.
Motion's been made. Do I have a second?
Would you be willing to amend the wording so it's not the scope of our authority, but to advise on the let me think about this. Best course of action for the planning board at this time.
Yes.
Okay.
So amended.
So do I have a second to the amended motion?
Do I second that?
Well, it's your motion, Adam. Marty has asked you to amend it. You said yes.
And I will second the motion.
And Marty is seconding it. Jean, you have any further comments?
If that is the consensus, and it apparently is of board members, I certainly will go along with it. I will not vote against that. I will vote for it.
Okay.
I think Evans wants to comment on it. If I'm reading this right. Did you want to add something, Evans?
Is it procedurally appropriate for me to comment at this point?
I don't know.
I don't know. I'm gonna let you do it if it's short, because we got to take a vote and we got to move on, because we are continuing with this hearing to get information. We're not stopping because of this. We're moving on the substance of the application.
Okay, well, I appreciate that. I just want to be clear on what the applicant's position is on this issue of what the effective delay
I
is.
think we know what the applicant's position is. But go ahead.
Okay. I mean, Mr. Block has alluded to it a few times. Others have alluded to, you've alluded to it, Paul. You know, as far as we're concerned, this board has already received an opinion in the form of an email from qualified town council that the hearing, you know, to answer Marty's question, which is that it's not this board's place to, you know, adjudicate this issue or to delay the hearing. To the extent the hearing is delayed any further as a result of this issue, the applicant does not consent to such delays.
Thank you, Evans. I think the whole purpose of what we're doing is so that we don't delay, so that we can continue with the hearing. Hopefully, we can get an opinion from an independent counsel, from an independent expert counsel, not to take anything away from Mr. Heap and his ability and his opinion, but I believe it's the consensus of this board that we want to not totally rely on Mr. Heap's opinion. This is so, there are so many subtle issues involved here that, and we're not delaying. I want to stress that. We want to move on here. And if we reach a point where we're ready to close the hearing and we don't have an opinion yet, this board will have to deal with that because we don't want to delay. Okay, any further comments from the board before I call for a vote?
Yes, I would say I have two comments. One, maybe we should have a time frame that they want that opinion by the end of September. It's
We
September 8th.
want the opinion as soon as possible. I mean,
And-
I'm not going to put time constraints on a lawyer we haven't even hired yet.
I understand. So that's fine.
In that same vein, should we put a cap on the amount that we're asking the select board to give us to make this higher?
I don't know that we can do that. I think we need to, first of all, somebody has to make a recommendation as to a lawyer who's an expert. I don't know anybody personally who's an expert in ethics law. We may have to ask Mr. Heap for an opinion. I have suggested that where Bruce Eisenhut worked for many years at the Board of our Overseers, he may know of somebody, but we haven't been able to reach him. And you know, we don't know what the hourly rate's going to be. We don't know how many hours our expert is going to guesstimate will be, how much, you know, I don't know that we're in a position right now to know what kind of cost. We'd have to ask the lawyer that we're looking to hire what they think it will cost.
You're right. Okay.
Okay, we ready for the vote? Mr. Block,
Aye.
Mr. Jacobs,
Aye.
Ms. McKnight,
Aye.
and the chair votes aye. Lee, please ask the town manager to authorize the funding and perhaps to ask Mr. Heap if he knows of an expert in the field. And I would ask you to continue to try to reach Mr. Eisenhut.
Right, well, I'll reach out to the town manager to request the hiring of special counsel.
Thank you.
Question, do we need a motion to vote to deny the request to pause the hearing? You think we need such a motion?
No.
Just keep going.
Just
Okay.
keep going.
Yeah.
Because that's not a motion in front of, that's, you know, that's,
Okay.
no. I have the next item on my list of what to discuss is to have the civil engineer discuss the changes to the plans that have been made. to inform us of the changes to the plans that have been made. Is that someone here prepared to do that?
Oh,
Yes, before Mr. Glossa speaks to that, Mr. Glossa is our engineer. Before he speaks to the changes to the plan, I just wanted to raise two issues for the board's attention. One is that there's been some changes to the facade of the building that faces Central Avenue, which is not really within Mr. Glossa's purview, so I can speak to that at some point.
Okay.
And the other is that yet another issue or allegation has been raised as to whether or not keeping the barn would be a violation of a provision of the bylaw that prohibits more than one non-residential building on a lot.
I have that next on my list. Do you want to discuss that before we have Mr. Glossa go forward?
It's up to you, Mr. Glossa first or that, either one. I just want to make sure that you know that I want to speak to that.
Well, yes, and we want to speak to it also. So let's discuss the barn then.
Okay.
Because it was presented to us in a letter or an email from Ms. Clark, Attorney Holly Clark, raising the issue of whether the barn would be an impermissible structure if the daycare center is built. We reached out to the building inspector, the building commissioner, Mr. Roach, and he agreed with Ms. Clark that our bylaw provides that you cannot have two non-residential uses, two non-residential structures on one lot, on one residential lot. So if the daycare center is built, the barn has to go. And
well, okay.
I'll let you speak to that, Evans. Go ahead.
Okay.
Excuse me, Mr. Huber.
You can call me Evans. It doesn't matter.
Just don't call you late to dinner.
So I know Dave Roach obviously pretty well. I think he's a great guy. He is not a lawyer, and I don't think he's that familiar with 40A, Section 3. There's obviously a provision of the bylaw that says that more than one non-residential structure on a lot is not allowed in the SRA district. But let's keep in mind again that we are under Chapter 40A, Section 3. Chapter 40A, Section 3 says, no zoning ordinance or bylaw in any city or town shall prohibit or require a special permit for the use of land or structures, plural, or the expansion of existing structures for the primary, accessory, or incidental purpose of operating a childcare facility, provided,
I'm going
however.
to stop you right there, Mr. Huber. You have represented to us that the use of the barn is not for the child center use.
Given that this issue has been raised, and upon looking at it, it's become pretty clear to me that the use and to Needham Enterprises, that the barn, because of this issue, the barn is going to need to be used solely for purposes relating to the child care facility. Otherwise, that language that I just read you doesn't apply. There was certainly a time when we did not realize that that was the impact of this bylaw provision. However, I would say that I don't think it's at all clear that an accessory structure is subject to that restriction that we are now discussing. There is another provision of the bylaw which explicitly states that accessory structures which are defined under the bylaw as a accessory use is other customary and proper accessory uses such as but not limited to garages, tool sheds, greenhouses, and cabanas. We're not building a cabana, but other accessory uses are allowed as of right in the SRA district. So there is a, let me finish, please. So there is, I think, a reasonable interpretation of the bylaw would be that the prohibition against more than one non-residential structure in an SRA district does not apply to accessory buildings. And one of the reasons I think that's a legitimate interpretation of this apparent conflict between the two provisions is that, for example, the bylaw excludes accessory structures and uses from the definition of gross floor area. It explicitly excludes that. So that is an indication that under the bylaw, accessory uses are treated differently, and space that is used for accessory purposes are treated differently than sort of the main space. But I also think that even if you don't buy that argument, the Chapter 48, Section 3 very clearly indicates it is not limited to a single structure. And so I think that provided that the barn is limited to accessory uses accessory to the childcare facility, which we understand would end up being a condition. That was not our original hope or desire, but I understand that that's where we find ourselves today. Provided that it was so limited that that the bylaw would otherwise prohibit more than one non-residential structure on a lot, it is overridden by Chapter 48, Section 3, which very clearly states that a bylaw that purports to do so can't be enforced. So our view is that even if 48 didn't exist, it's not as simple as looking at the portion of the bylaw that says that you can't have more than one residential structure on a lot. You still have to get past the question of whether or not accessory structures are subject to that restriction. But even if they are, 40A prohibits the board from interpreting the bylaw in that way or enforcing it in that way.
Do you have any comments from other members of the board?
I have a question. For what purpose related to the daycare center is the barn proposed to be used?
At the moment, no purpose other than storage.
Storage, yeah, and you've said that before.
At the moment, as I said, I'm not going to pretend that we have been aware of this issue from day one. We were hoping that it was going to be able to be used for other purposes as well. This issue being brought to our attention now, I think we have to live with what Chapter 48, Section 3 says. To the extent we are relying on Chapter 48, Section 3 to override or trump the bylaw provision to the extent it would otherwise prohibit this barn, if we want the protection of Chapter 48, Section 3, we have to live with what it says, which is that it's a, it's a structure for primary, accessory, or incidental purpose of operating a childcare facility. So any other uses outside of that, we recognize that we would not be able to do.
Thank you.
Mr. Block? You muted, Adam.
I keep muting myself. I apologize. I do have some comments and questions. My first question about the barn is actually for Mr. Glossa. Mr. Glossa, what's the square footage inside the barn?
Well, I can tell you what the square footage outside of the barn is because the barn It's
That'll work.
60 feet by 40 feet, so 2,400 square feet.
So 2,400 square feet. Thank you. So Evans, we've heard representation by you and by Mr. Glusing, and that Needham Enterprises would have have predominant use of the barn. Not quite that language, but Mr. Glusing has said that that Matt would store some things there, equipment, and I think that you had mentioned that as well. And on direct questioning with Miss Day, she mentioned that she would use it, but really for what amounted to incidental storage. Of the 2,400 square feet, she used 500 square feet. It's a pretty big space. That's the size of an oversized 2-car garage, packed with a lot of chairs, toys, wipes, and clothes and whatever else daycares would supplies a daycare would have, cleaning supplies, etc. On its face, it's just not realistic that it as a accessory to the daycare facility. And so I understand you're interpreting the Dover Amendment a little differently, and yet I think I'm satisfied that based on what we've heard already, that this thing becomes a second use that's outside of the use of the primary use. It's not really accessory to the primary use, and therefore it's got to go. But I'm also going to say this. I'm going to say that the only way I want to see the barn stay, I've been there, I've looked at it, I've touched the building, I've knocked on the wood. I understand that it has no historical significance, except that it may be regarded as a callback to yesteryear, because that was effectively a farmland before, and a barn is kind of a farmland thing. I get that. And in homage to its history, the concept of its history, not the structure itself, I would say that it would be personally, I'm going to advocate for a substantial setback. And the setback that I'm going to advocate for a host of reasons I'll get into later when we deal with that issue, is going to pretty much mirror the closest analogous use in the geography, which is the temple, and that's 200 or 213 foot setback. If the building designed by Mr. Glusing were to stand and be, and then we push that back, that's going to necessitate the barn go. There's a few things to that. One, you already have demolition crews there to demolish the house and the second garage. So the incremental increase to demolish that barn, which would get really demolished in less than a day, and the cost to haul is regarded to me as incidental to the developer in terms of a cost. He's going to spend $1.5 million in construction costs. If you spent $30,000, which is the cost of demolishing a single family house, which is not, because it's only incremental because of the other structures that are going to be demolished, that would itself would be 30,000 against 1.5 million is regarded as incidental.
Let's not forget, Adam, if I may.
I would like to respond to these comments.
Yeah, you will. You will have a chance. I want to add to that he already spent 1.2 million to buy the land.
And that's also a fair point. Now, having said that, so we're at costs of somewhere maybe 3, whatever. But the point is that that barn, that it, I apologize. I'm going to come back to my other thought, that that we push that building back because it's going to make other improvements to the area and the geography. The only way, frankly, I see, and Pat, I don't know if you can hear this or not, the only way that I see the barn staying is if it really becomes part. If you're saying the structure is so valuable that it needs to stay, Evans, which I regard as a valid argument. The only way that thing stays is when you include it in the design of the structure. And for me, what I love about that, thinking about all of the times I've stopped on the highway to look at farms and barns with my now 9-year-old, who at the time was 6, he still builds with Legos. He still builds farms. I would love to call it, the Barnyard Center. And you can actually include that as part of the marketing, and that would be fun. And it's an homage to the geography as being farmland from yesteryear. And I see that as the only way in which this thing is going to be included. To move it makes no sense. And either it's demolished or it's incorporated as part of the facility. Even if that became, even if that became a bit of the play space area in conjunction with some other additional use, once it's incorporated into the envelope of the structure that the applicant is preparing, I think that's a great idea, but that's the only way I would ever support keeping the barn.
Mr. Chair,
Yes,
I wonder if we could have discussions like this later in the proceeding when we're at the point of making a decision, because really what we want to do at this hearing is to get information about what's proposed, what our town officials think of it, what the traffic review said, and what our traffic review we hired said. And I really want to see that go forward here, and that we get that done tonight to some extent.
so you want to defer the discussion about the barn?
Yeah, I mean, we've got the information from Evans Huber on what's proposed, and we can take that into account as we go forward in making a decision.
Mr. Jacobs, you have any comments about this?
No, I agree with Gene, although Evans has been wanting to comment for the last 5 minutes, so.
As has Pat.
Okay, Evans. You're on.
I'll be very short because I agree. I would like you to start hearing about the traffic issues and the changes to the site plan. I think we've really improved it since the last time. But I would just say that in my view, if this board were to vote that the barn has to come down, I think that is a very clear violation of Chapter 40A, Section 3, because you are effectively prohibiting the use of a structure for a childcare facility. There's nothing about, no, Adam, please let me finish. So we can leave a more full debate about that to later, a la Gene's suggestion, so that we can get to some of the substantive issues or the factual issues about the project and the proposal. That's fine. I agree. I would like you to hear about that because we think we have a good proposal and we think we've addressed the traffic concerns, which is one of the big issues here. But I just want to lay it out there that we are not going to agree that the board has the authority to order us to take the barn down.
I think that if this board finds, as a matter of fact, that the barn is not in fact accessory to the child care center use, then we do have the authority to condition that the barn come down to conform to our town bylaw, which is a valid bylaw. And that's, I understand your position that you now want to fit the barn into the use of the child care facility in order to save it. But that's what I see is happening here, Evans.
That's absolutely what's happening. I'm not pretending otherwise. You are correct. Originally, we did not understand or see that we had this limitation on what we could use the barn for. Now that this issue has been raised, we recognize that that we do have to, in order to get the protection of Chapter 48, Section 3, we have to do what Chapter 48, Section 3 says, which is we have to use it for purposes. And by the way, not just necessarily accessory purposes for the child care facility. So, you know, we can't use it for something else. What the bylaw says is you can't have more than one use there. And so we understand that it's going to need to be related to the child care facility. So again, you know, we could debate this for another 45 minutes and not get any evidence in front of you about these other issues. So I would like it if we could move on to either hearing from Mr. Glossa and or Mr. Gillen.
Ms. Day, you wish to comment? You're muted. You're muted, Pat.
I
Thank you.
think I'm unmuted now.
Yes.
I just wanted to make a comment. The space that we're in now has a lot of storage space. The building we're building has a lot of kid space for children, but it doesn't have a lot of storage space. And just to put things in context, because we have the exact same amount of children here that we would want to put, it's just a transfer. Right now, we can fill 3 double garages. So I don't know if Mr. Glossa knows like those basic measurements, but not only can we fill, because with the bikes and the buggies and the outdoor equipment and the outdoor tents and all this stuff we have now, and it's not available to us right now in this space because it's all kid directed space. But right now, if you came over here, we could show you 3, we have a double garage right here, storage unit here, storage unit, there's a whole storage room that we could fill, and 3 sheds. I don't know, I would think at least 3 double garages. So storage is, if you want to have a really phenomenal place for children, then you need storage. And I love Adam's idea. I don't want to talk too much, this is a busy night, but I love that idea. It would take research because there are state guidelines we have to follow. You know, and you know, it would be great, wouldn't it, if you could even attach it? But that's, you know, it would still be only for that same amount of kids and only for, you know, for store, but don't overlook storage. Storage in a childcare facility is at a premium everywhere. We've been blessed here. But the drawings that you're seeing cut out a ton of it. So when we heard this was a possibility, we were all like, because if you saw how we're fitting in six passenger buggies for walks, and enough said, but we could fill it. Sorry.
No, it's okay. I see 2 hands raised among the attendees. Matthew Heidemann and Holly Clark. A 3rd hand just went up. It looks like we're going to defer the discussion of the barn. The issue has been raised, the issue has been joined for future discussion. So I'm going to ask if your comments can wait until we're actually fully discussing it. That would be great, but your hands are raised, and so I will call on Matt Heidemann first. If you can keep it short, Matt, because we're going to have a full discussion of it at a later date. Remember to unmute yourself first. Oh, there you
Yeah,
go.
Mr. Alpert, I appreciate the opportunity as well. And thank you to everything that's been said here tonight. And honestly, I am not a lawyer, so everything I say is coming from either common sense or just personal, just business sense. I can say since we ever started this endeavor back in March of maybe March of this year, sorry, where we finally found out Mr. Borelli's intention for the property, which kind of eluded the entire neighborhood, which honestly, everything about this project that I want to say has been very stealth and very unforthcoming. The barn plans have been significantly unforthcoming to the point where Mrs. Day and I have had conversations directly ourselves. And I know none of that is on the record, so none of that can be brought up today. But honestly, I have heard that the barn isn't needed, the barn is now needed. And oh, by the way, I live in a 1,700 square foot house right next door. And honestly, I house a family of 5 in 1,700 square feet. So the fact that you're sitting there telling me that you need a storage unit of over 2,000 square feet just makes absolute unridiculous sense. And that's all I'm going to say on this matter. You take the barn down, you can push the building back, you get less types of pushback from the neighborhood. And it addresses traffic issues. That's all I'm going to say. Thank you.
Thank you, Mr. Heidemann. Ms. Clark, Holly Clark. And since it's the first time you've spoken, please remember to give your address, Holly. Remember to unmute yourself, please. There you go.
Are we good now? Yes?
Yep.
Okay. Hi, I'm Holly Clark. I live at 1652 Central Avenue. And I did hear you, Paul, and I will be brief. I think Mr. Huber is misreading the bylaw. He is misreading Section 3. The bylaw is very clear that you cannot have 2 non-residential buildings on a residential lot. It's also clear you cannot have two non-residential uses on a residential lot. It's clear, it's legal. It would be upheld under any analysis if you got into Section 3. And I just wanted to say that because people do marinate and think about comments as they got made. So I am happy to hold back any further discussion. But I will say one thing. If this is another change in the plan, that suddenly now this is going to be part of the childcare facility, I just don't understand when we actually say, what is the proposal that we're considering? Because if you're now saying you're going to add another 2,600 square feet to this, like it just opens a number of doors. So, but I am happy to withhold further discussion until later.
Thank you. Stan Keller, you've been patient. Please remember to give your address. And please remember that we're going to have a full discussion on this at a later date.
Thank you. I think I figured out. Can you hear me?
Yes, we can see you.
All right, I'll be brief because I didn't want to leave things with the barn as they were, because frankly, I think the discussion about the barn is surreal. And nobody's asking the real question. First, let me just backtrack that the issue here is what reasonable.
Will you please give us your address?
Oh, I'm sorry. 325 Country Way, a long time, very long time Needham resident and Country Way resident. So I know the property well and I know the neighborhood well. The real issue lurking here is what reasonable restrictions and conditions you can impose on this property. that address the concerns that the community has raised and that I can see that board members themselves have raised. Nobody has asked the question, why in the world would someone build a new multi-million-dollar facility and keep that barn, that old antique, if you can call it that, barn as part of the property? And the answer doesn't come through. We're hearing make weight now. We're hearing change stories about usage of the barn to fit in. And the fact of the matter is the barn is a Trojan horse. The barn is there so that it can be used as an existing structure to limit how much of the property can be used for the daycare facility. And it seems to me the job of this planning board is to look at the property as a whole so that appropriate and reasonable restrictions can be imposed to address the concerns. You can build a childcare center, but let's look at the barn for what it is. And it's not make weight. It's not now all of a sudden we've discovered we can use it as part of the facility. We can call the place the barnyard. We can have storage there. If you're building a new facility, you design it so it has the requisite storage. And so I would urge you to ask the right questions. What are the reasonable restrictions that are necessary? Are there impediments to those restrictions? And the fight over preserving the barn is really a fight over the development of the rest of the property to prevent reasonable restrictions that are necessary for traffic control, for safety, for site planning, and the like that would encroach further on the property. And so let's look at things as they really exist and the reality of things. I'll address that more later, but I wanted to at least put that on the record. Thank you.
Thank you. Ms. Buckley, you wish to speak again? Shannon Buckley.
I just wanted to say from a teacher's perspective that also a lot of people have questions about storage and our playground and our drop off and parking spaces. Come see it. We kind of have a joke going that one day we're going to come out and see all of you sitting in beach chairs in the parking lot. Come do it. We welcome you. I think the barn would be amazing. I think the kids we talk so much about farming. We have gardens, we have tomato plants growing, we have lilac plants growing. We have so much growing and prosperous at our school that a barn is so cool to drop your kid off at this school that is part of farm. And we could have so much going for us there. So I invite anyone who has questions about the school or what we're teaching or what we're doing or how we use our storage to just come see what we're doing. Come look.
Thank you. Okay. I think we've agreed to, that's the last of the comments. It's the last of the hands raised. We're going to move on. So let's move on to the presentation about the changes to the plans to date. Although Evans, I'm going to throw it at you. The only two things that I have left are a discussion of the changes to the plans and the traffic. Do you want to do the traffic first?
No, because I think the changes to the plans will be faster. Because
Okay.
the traffic is sort of a two-part thing. You're going to hear from Mr. Gillen, and then you're going to hear from Mr. Diaz. So we're clearly not going to get that done in the next half hour, but I think we can go over the changes to the plans in the next half hour.
Okay, great. Thank you.
So in order to do this, I need to be able to share my screen. Mr. Glossa will be speaking, but I'm going to do the screen sharing duties.
Okay. Alex, can you arrange for that?
Yeah, I think he can. I think we set it like that. Evans, do you see
Let
someone?
If Evans can do it, it would be a little easier for him to.
Evans, can you try it?
Yeah, I'll give it a shot. Hold on here.
Just do the landscape plan, I think.
Yeah, I'm just going to try to bring up a plan. Did that work?
It says Evans Huber. There we
There
go.
you go.
Okay, so this is the most recent iteration of the plan, and it does include some changes that I think are significant, and let Mr. Glosses speak to them.
So as you said, Mr. Chairman, my name is John Glossa. It's Glossa Engineering, 46 East Street in East Walpole. And basically, the changes to the plan, since you've seen it last, were driven by the letter from your traffic peer reviewer, John Diaz. So I'm going to sort of read from John's letter. It's just the site plan review part, and it starts with number 14, where John's asking for pavement markings, directional arrows, etc. So you can sort of see, if you looked at the site plan, there are a little bit more, but you can see that they were added to the plan. Directional arrows, center lines of the pavement, of the travel lanes, etc., etc. John's next comment, number 15, has to do with, he's asking me to sort of identify the width of the sidewalk, which we show as 5 feet. And then if you look really closely, and I'm not asking you to zoom in, Evans, but it's a double line, the curb. So the curb is 6 inches, and then the pavement is either 24 feet or 24 feet plus the 8-foot queuing lane. So John, I did not change the plan. I think that the plan is adequate the way it's shown. And if you go to sheet 6, and I'm not asking you to do this, Evans, but there's a detail of the sidewalk, the curb, and the width of the pavement. So I think that that is adequately shown on the plan at this time. So the next thing John was asking is about, if you look just behind at the rear of the building, kind of between the building and the barn, but closer to the building, there's a little area there called loading. And that was described to me as an area where school supplies and stuff like that would be dropped off. And it was told to me that the vehicle that would drop that off would be, you know, sort of at the maximum would be a kind of an Amazon type van, that size, maybe sort of that WB Mason truck that comes, a 6-wheel truck. So those trucks can easily just park in that loading zone and then back up and travel around that center island. So I didn't really make any changes to the plan. John was asking me to provide a template to show how that truck would come and go. If that's what's going to make this fly, I'll gladly do it, but I just didn't think that it was necessary at this time. Number 17, John was saying to add what he calls curb stops, what we call concrete wheel stops, at the ends of the parking spaces where they abut the sidewalk. And the reason John's asking for that is so that the front bumpers of the cars don't overhang the sidewalk, and thereby making a 5-foot sidewalk down to a 3-foot sidewalk, let's say. So we added those to the plan. You can see concrete wheel stop 2 feet from curb. And so we added those. The next one had to do with the barn building. That has nothing to do with me. The next one had to do, number 19, was the shape of the island. So we had it kind of a circle. I think John was correct. That was kind of making a little bit of confusion on a driver, thinking it might be like a traffic circle. So it's not. So we kind of made it a little bit more teardropped. So the people in the queuing island, which is one of the changes, the queuing lane, which is one of the changes that we made to the plan, are forced to go around the center islands. People who want to get to the parking spaces where it says 6 parking spaces, and then at the rear behind the barn, the 9 and the 10 parking spaces, they're going to go in that middle lane, and they're going to be directed by a painted line towards the rear of the parking, so there wouldn't be any confusion with them. And then obviously on the other side of that line, those are the people who are leaving the parking spaces, and they're going to drive out on that side. Then number 20 was, has a second driveway been considered? And we did give John a plan kind of showing a second driveway, but I just believe that that kind of, it's a little bit difficult to make that work, kind of makes more pavement and kind of makes less availability for parking, believe it or not, unless we're going to start sticking things closer to the houses on Country Way, which we, decided we didn't really want to do that, or the owner decided he didn't want to do that. So the other thing is the parking drop-off area provided in the front of the school. And again, the potential tenant here wants the parking, wants the front door essentially, or the main access door to be at the rear of the building. It does make a lot of sense to me as a civil engineer, because it is giving the ability for at least 10 cars to queue up in that queuing lane while the children are being taken from their car and into the school. So it makes a lot of sense to have that door at the back rather than in the front. So the number 22 has to do with ADA handicap sidewalks. And so the ones that are at the handicap spaces, so next to the loading area. So the way we do that is that you can see right where the cursor is that would be actually level with the pavement. And then those little ramps going up and down are ramps that are less than 5% in slope. So they still meet the criteria for a sidewalk under ADA requirements. So there's no, nothing, it's not a ramp. So there's no, nothing really other than just a sidewalk required there. And then in the front where the sidewalk, the existing sidewalk is going to cross the new curb cut there. I will say, John, that the draftsman didn't draw that the way I asked him to do it. And that is that that curb would actually end at the sidewalk and then begin at the sidewalk again and go out to Central Ave. So that is actually a sidewalk that would be sort of like you're walking in a city, right? So you don't have a handicap ramp there. You just stay on the same elevation as the sidewalk. So John and I can talk to that, but I think that if we just sort of show that correctly, that goes away, that comment. And then the final one had to do with drainage. So you can see from those contour lines, those finished contour lines that are just on the north side of the school along the road or along the driveway where the queuing lane is. So those contour lines are indicating that that is a slope going down from the, say where the door is, where the children are going to go into the school. It's going down towards Central Ave. So what John asked us to do, it doesn't show on this plan, but it is on the grading and drainage plan. We put a set of catch basins right close to where the stop line is. So there's catch basins on both sides of the driveway there.
Is it on one of these earlier sheets?
Yeah, that's the one right there. So if you can just blow it up a little bit and then move it so you can see Central Ave, and you can maybe give it, yeah. There you go. So you can see that set of catch basins that we added. So that would actually be a little bit of a low point in the driveway. So everything slopes down from the back of the site towards those catch basins. And then from there, the pavement would actually raise up to meet the sidewalk. And then we'd have the sidewalk and we have the apron. So there's an existing catch basin there, which is kind of giving us fits. But so John had asked us to get rid of that sidewalk. It's the one that's out in Central Ave. This plan doesn't show it, but on hindsight, looking at it again, I think John's correct. So I'm sure we're going to be coming back with some revised plans, and we're going to get rid of that catch basin, or if we do leave it there, it's where that little cutout is. Yeah, right there. So there's a catch basin there. Unfortunately, on Central Ave, even if you look at the catch basin across the street, they're sort of set back from the edge of pavement, which is fine. I'm sure they work great. It doesn't appear to be a problem. It's kind of a low point. Central Ave is very flat in that area. So I was reluctant to move that catch basin. So I'm going to talk to the DPW. There is a way we can offset the grate from over the sump, because there's a water line right there that we need to keep in mind. So we're either going to offset that grate and keep the sump there, or probably put a two sets of catch basins on the north and south side of the entrance to the daycare center and change that catch basin to a manhole. So at first I didn't think it was needed, but the more I looked at it and the more I looked at some other, actual field conditions at some other places around Norwood and Walpole, I think John was 100% correct that that catch basin needs to be either moved out, or two catch basins, one on each side of the entrance to the site. So those are the things I changed, and a couple of things that I didn't change, but I'm sure that none of these things that we didn't change really are unsolvable issues. So with that, Mr. Chairman, I can answer any questions that you might have.
I'd like to just jump in here if I could.
Go ahead.
From my non-engineering perspective, but from my sort of layman's perspective, I think John kind of glossed over what I see as the most significant change since the last time we were before you, which is the addition of this queuing lane. A comment was made in one of the neighbors, by one of the neighbors, that when we previously had, it was just an entrance lane and an exit lane, that somebody who wanted to get back to the parking area would be blocked by people who were queuing to drop off their children. So this driveway that you're looking at now has been widened compared to the previous plan. And so there is a queuing lane here, which can hold 10 cars. Show you a little graphic here. So people come in, they can turn into this queuing lane, and then sort of naturally, if this queuing lane is full, and there's, Mr. Gillen will talk about the analysis as to why we think as a matter of reality, that's never going to happen. But if it were full, you would come in and you would be naturally directed back to these parking areas, so that the cars waiting to drop off their children will not interfere with the free flow of access to the parking areas. And I think it's actually a really good design. Then you come down here, you drop off your child, you go around here, there's a stop sign here, a line and a stop sign, and then you make sure that there's no cars coming either direction. You go across and you can get into the exit lane. Or if you are parked back here in these parking spots or in this rear parking area, then you just have a clear access to the exit lane once you're done. So I think this, it addresses a legitimate concern that cars waiting to queue in our old design or waiting to drop off their children might block and increase the likelihood of cars backing up onto Central Avenue. I know that's a concern that's been raised many times. And this redesign, I think the most important feature of this redesign is that there is now a separate lane for parents waiting to drop off their children from those who are just accessing the rear parking area. or who come in, want to be in the queuing lane, can't because it's full. And so they are naturally directed by the layout of the site to these parking areas.
So in anticipation of a question that's going to be, or may be answered, we did not have to move the building to accommodate that queuing lane. We simply widened the driveway on the north side of the property.
But another feature of this that I think is important is that it may seem sort of minor, but this curve has been added right here. And so when you come around that curve, if there's room in the queuing lane, you can get in the queuing lane. But if you come around that curve and the queuing lane is full, your natural tendency would be to just continue back down this open access to the rear parking areas. Previously, it was just straight. So if you pulled in, you might be behind somebody who's trying to wait to drop off their child.
Okay. If you guys are all set, I'll take comments from the board. Let me see if I can move this so that I can see both, have all the board members. Yes.
Do you want me to take this off the screen?
Not yet, because they may have questions that relate to the plan. Jean, you can go first.
Yes, I recall a comment, and I think it was made by our town DPW rather than by the traffic consultant about redoing the sidewalk along the entire frontage of the property. And this is something we have frequently asked for in developments. And I don't see anything about that being proposed here. I wonder if Mr. Evans or Mr. Glasser would comment on that. Am I taking this about by surprise? I believe that was on the comments I read today.
Oh, that was part of comment 22.
Oh,
that
in your
was raised.
response to that, I didn't fully understand that. Could you repeat what you said in response then?
Well, so comment 22 just says the proponent should construct fully compliant ADA sidewalks along the property frontage and tie into the existing sidewalk. So we intend to.
At the property limits. Tie into the existing sidewalks at the property limits.
Well, there's a sidewalk there now.
Right, but it's like a 2-foot non-ADA kind of paved path. It's by no means an ADA sidewalk. The comment was to provide new sidewalks along the whole frontage, and then what's outside your control, outside your site, you tie into the existing at the property limits. To Gene's point.
That's not that's, kind of goes beyond an engineering question. There's an existing sidewalk there. So it's sort of a legal question, if you ask me. It's something
Well, I'm only anticipating that this is something that board may require as a condition if this is approved. And so I really am just anticipating that and consider you should think about it now.
Well, I can ask my client.
Jean, if I may ask, would the expansion of the sidewalk to accommodate ADA sidewalks, would that just be along this property, or would it, and I don't even know if we have the authority to do this, would it extend from say Country Way all the way to the Temple Alley driveway? Because it doesn't make sense to me to just have it along the property line and then have this 2-foot sidewalk on either side of it.
Well, I think the comment that was made that I'm recalling was only about requiring the improvement to the sidewalk along the public way, along the frontage of this property.
Yeah.
I know, I think in other cases, I recall the new subdivision was called Sunrise or Sunset subdivision off Central Ave near Great Plain Ave. I think we did require sidewalks to be further extended. But I'm not sure where this doesn't involve a subdivision. I'm just not sure of our authority to go any further than the property itself.
Yeah, so comment 22 from GPI is the proponent should construct fully compliant ADA sidewalks along the property frontage and tie into existing sidewalks at the property limits. And then a further response to that is this comment does not appear to have been addressed.
Right.
Right, I misunderstood, Mr. Chairman. I thought he was just, and I read it the same way you read it now, but I didn't read it that way at the time, unfortunately. So I thought that John was just talking about at the new curb cut. So let me speak to my client to see if he wants us to show it that. Like I said, from an engineering point of view, it's no problem to show it that way.
Any other questions or comments, Adam? You're muted, Adam.
I'm usually so much better at that. I would say that there are definitely improvements here. I think the widening of the driveway, creating a larger access point, is an improvement. We don't anticipate, I guess, that many people parking. So when you make a left on the other side of the teardrop, you're not theoretically stopping anyone coming off Central and queuing up that middle lane to get to parking. The expectation is that they may stop for a minute or for seconds, but it's really very short. I'd like to, at the last hearing, I think, Mr. Gloss, I'm going to ask you to go to sheet, I guess, I think it's sheet 9. Evans, are you able to put that up?
We're looking at sheet 9 right now.
I may have a different plan set then.
I thought this was sheet 5. No?
No, that's sheet
So
9.
we submitted this plan set that we're looking at right now is dated June 22. Here, I'll click up to
So
that.
sheet 9 though is the same. Attorney
So this
Huber,
is the plan set that we have most recently submitted from the engineer. This is the cover page that I put up on the screen right now.
Which you had couriered to us, correct? With a summary note of the changes made?
Yeah, so sheet 9 is what we call the construction period plan. So
then can you bring up 8, sheet 8 of 9?
I don't know if we have all the sheets available because I really wasn't anticipating.
Is this the sheet you're looking for?
Can you scooch it over? Scooch is a technical term.
Sheet 8 is the sewer construction, the sewer extension plan.
Okay, we can hold this. We can hold this. Hold that, please, Evans. So, in fact, can you actually scooch it down a little bit so we can see more on the southern side of this?
Like that?
Yeah, it's perfect. Whoa, that's perfect. So at the last time we gathered, I had made a comment that on the south side I think, Mr. Glosser, you mentioned that you were already satisfied with the proposed underground detention basin to capture all of the water that would come onto this property, and that detention basin was between the barn and the proposed daycare center. And then I'd asked a number of questions about the slope on the south side. From what I see, it looks like it would go from 205, 204, 202 down to 199 or 198. We dropped 6 feet. And there is water that's going to move down a slope off this property. And I think you had mentioned that there was a natural slope on what I'm going to call the southwest corner of the lot. But subsequently, I saw that you did put in another proposed infiltration basin, which I think is designed to get the water off of the sidewalk on Central Avenue and flowing into the street itself. But the other point that I raised is that I don't want any water from this going on to, for instance, Matt Heidemann's property or any of the other properties that abut this from Country Way. And I thought that you were adding, I might have been mistaken, a detention basin on the southwest corner, as well as what's really the northwest corner, to remove more of that surface water. I understand that you've got, downspouts and gutters, and you're going to catch some of the water, a lot of the water through that system into that existing or the proposed infiltration detention basin, underground detention basin. But there's still a lot of water on site. And that water is on a slope heading away from the property onto other people. And is that correct, Mr. Glosser?
No.
So what is the error in my reading? There's no.
So you need to look at those. See all those little numbers there, those spot grades?
Sure do.
And if you look at them closely, you'll see that Heidelman's property actually is higher than the properties. And I pointed this out to you before. There's a closed contour line. It's the 198 contour line. So there's a closed contour line right, yeah, down below, right there. That one closes off. So there's a little area there that would naturally hold water, and then it would soak into the ground. The soils here are glacial outwash. So if you want your soils lesson, that's soils that washed out 15 to 10,000 years ago when the glaciers were here, from the glacier in torrents of water where heavier material, rocks, gravel, sand, fell out of the flow of water first. Silt and clay went down to the bottom of the hill, wherever that was at that time. It was probably the Charles River now. So these soils are what we say free of fines. And I did a number of soil tests in this property and dug down 10, 12 feet, and it's glacial outwash all the way down.
What does that glacial outwash mean? Are you saying that means that it's going to hold all the water from this property?
No, the water soaks into the ground. So when you have grass, trees, that sort of ground cover for this type of soil, you don't have very much or maybe even no runoff from rainfall. And that's why the soils are sort of a double-edged sword for us, because in the existing condition, and I don't have the drainage calculations right in front of me, but in the existing conditions, other than the paved areas on this property, there was probably no runoff. So therefore, we had to catch all of the runoff and put it back into the ground. That's why there's that massive set of leaching galleys that you see between the barn and the back of the
Right.
daycare. So in the other areas that are grass, there is very little or no runoff. In the smaller storms, the more frequent storms, the storms, you know, that happen on a yearly basis, there's no runoff from this site. And any runoff in this area where you're talking to, where Heidman is not going to flow onto his property. His property is flowing onto this property. So I'm unclear as to why.
So am I wrong then? I see an altitude line of 205 feet, 204 feet, 203, 201, and I see Matt Heideman's property.
Yeah.
Greg, someone else's property. Greg, someone, I can't read his the name on that property clearly. It's but I can.
Darg, D-A-R-I-G-H.
It's 202 feet, which to me is about 3 feet lower in elevation than that slope. And then on Matt Heideman's property, his line ranges between 199.3 to 201, but either way, that's still below the 205 feet where Evans
I think,
cursor
Adam,
rate.
if I can just help explain it, that
Please.
close contour that John was referring to, that 199 contour, that's the low spot between the two properties.
Right
And
here.
it might help, I don't know if they have the data, but it might help to continue those 200 and 201 foot contours onto the other property if they can provide that. But that loop there is like a little pond there. That's the low spot. So you have a situation where both properties are coming in like this, and that 199 is where the low spot is. So yeah, you're right. It's the site building is at 205, but from that 199 you start to go up to the adjacent property.
And the other thing, Mr.
If
Block,
that makes sense.
So Mr. Block, if you think of it this way, think of it as a piece of plywood on a slope, right? So in the existing condition, we have a piece of plywood. It's up at the back of the proposed building, and it's essentially at about elevation 205. And then it drops like a plane, right? Up one steady slope down to about 198.56.
Yes, exactly.
Okay. All right. Now wait, just listen to me for 1 second. Okay. It's a piece of plywood and it's dropping at one continuous slope. All right. So that's happening in the existing condition. It starts at 205. It ends at 198 and a half, 198.56. So take that piece of plywood and cut it into 3 pieces. The piece on the higher side is flat as we can get it. We just want a little bit of water to run off of that. We don't want it flat to make a puddle, but we have it flat. Then we take a piece in the middle third of our piece of plywood, and we put that at a steep slope. Then we take the last one and we put it flat again. So by hydraulics, we've done nothing. We've actually slowed the water down. We have not increased the rate of runoff to that low spot. We've actually slowed it by making those level areas between that slope. So if you just look at that slope, yes, from the top of that slope to the bottom of the slope, you're right. The water in that little instant might run a little faster, but overall, which is what we want to look at, it's actually a better condition. And it's a little trick we use, especially when we have good soils like this, to make areas where rainfall is going to soak into the ground before it becomes runoff. So that's what we're doing. And we're not essentially getting rid of that little closed contour down the bottom. So if anything does flow down there, it has to build up pretty high. It has to build up, 7-8 inches before it's, going to sort of spread out and get onto Matt Heidman's property. So the drainage calculations bear us out. I can go over those with you if you want me to someday, or just common sense tells us that we're not really changing anything there, keeping in mind that all of the rooftop and pavement drainage goes into that huge underground set of leaching galleys.
All right, folks, it's 10 minutes of 11. I'd love to continue to listen to this discussion, but it's getting late. It is late. Can we continue this discussion at the next hearing?
Sure.
I see that there are 3 attendees who wish to speak, and I'm hoping that it can wait until the next hearing, because I wanted to put in a hard stop before this. I let you guys go because you're in the middle of the conversation. But can I have a motion to continue this hearing until October? Alex, what's the date? October 5th?
October 5th at 7:45.
Correct.
At what time?
7:45.
Can I have a motion to continue this hearing to October 5th at 7:45, please? Adam moved. Jean, was that a second?
Yes, second.
My motion.
Oh, it was Marty's motion.
Oh,
Okay.
sorry.
Any discussion? Hearing none. Jean McKnight,
Yes.
Marty Jacobs,
Aye.
Adam Block,
Aye.
and the chair votes aye. Thank you, gentlemen. Sorry we didn't get to the traffic.
We
A
should,
lively discussion tonight, and we're going to have a lively discussion on October 5th. For those attendees, we're not meeting on this matter on September 21 because I am not going to be available, and so we won't have a quorum to continue this hearing on that date. That's why it's being postponed to October 5th.
Mr. Chair?
Yes, Adam.
So in addition to just me getting a little bit more clarity on the gravity of water on that site, I just want you to be aware that it's Dave Lazarus and Matthew Heidemann who had their hands up.
Yeah.
And when we finish this discussion about the water, and I appreciate Mr. Gloss's indulgence, that when you return it back to the attendees, that you pick up from where we left off. So I just, for the record.
And Holly Clark had her hand up also.
Okay, you saw that, good.
Yeah, I did. I've been keeping I've been watching.
And Mr. Chair,
Yeah.
I just wanted to suggest that Mr. Glasser, and he's speaking of some further changes that he's going to make to the plan in response to GPI comments, that at that hearing, we have the revised plans.
Yep.
You will.
Okay.
Good night, folks.
Good night. Thank you.
Thank you.
Lee, are we all set? Can we adjourn?
Well, if we could just take, if Natasha joins us, I'd just like to take a couple minutes to talk about committee assignments. To move that
Okay.
along.
Let's see if we can do this quickly.
You don't need me for anything further, do you?
No, thank you, Evans.
right,
Unless you
thank you.
want to be on a committee.
Huh, I do that in Wayland enough.
If Natasha's coming back, she said she was going to be coming back, remember, but maybe she thinks we're not going to meet again.
Want me to text her?
Yeah. Let's see if I have her in here.
There she is.
Yes, it is.
Oh, she's back, good.
A divine miracle.
She said she was coming back. So I just want,
Coming back.
I just want to take a couple of minutes on committee assignments. And actually, Natasha, since we last spoke, I learned about another committee that Kate's trying to fill up. And so I know we talked about the Affordable Housing Committee, but I just want to make you aware of this other committee so that we all make informed choices here about what we really want to be working on. So Kate mentioned she's creating a committee that's going to basically create a climate action plan. in conjunction with Hank, and I know you're very interested in sustainable development and net zero. So she's looking for a planning board appointment on that committee. And then, of course, we need 2 appointments for the Affordable Housing Study Committee. You guys need to decide who you want to have serve on those 2 committees. Additionally, I was contacted by the town manager to see if the planning board was interested in participating in a committee she's going to be creating, which is going to study the existing, there are 2 transportation committees currently in Needham. One is focused really on roadway improvements. The other is focused on mass transit kinds of issues. Gene, I think Steve serves on the transportation committee that's really focused more on mass transit. The purpose of this committee is to look at what is the appropriate committee structure for managing transportation issues in Needham. Should this group be merged into one committee? And if so, what should be its charge? Currently, the planning board has an appointment on the transportation committee. So the question is whether or not you want to participate in this group that's going to be studying that issue. And then I think identifying the key transportation issues that the town will be focusing on over the course of the next year.
Who's our representative on the transportation committee?
Steve Knight.
Steve McKnight.
Yeah, can't Steve represent us on this joint committee?
I can ask Kate that. She wanted to know whether or not the planning board themselves wanted to have a member participating.
Yeah, I thought that was the question.
Yeah.
I guess one question.
If we appointed you, you could keep an eye on your husband.
Don't know whether that would be a conflict of interest.
Oh, please, I don't want special counsel for that.
By the way, in case you haven't noticed, Marty signed off.
Oh, yes, thank you.
So he's not taking part in this discussion.
So Lee, I have a quick question for you. Is there some, do you have some type of information of all the committee? I think we talked about this earlier on, about all the committees that the planning board participates in so that we can look at it globally. Is that
Well, right now, I think the only committees that we're participating on are the CPC, this Affordable Housing Committee, which is really our committee to study this issue. Then when we'll take the lead on it, and there'll be 2 members assigned to that, and whoever you guys decide is appropriate to chair that committee. And then it's basically to participate in this new committee we've been asked to participate in, which is going to develop the action plan. So those are the only committees that I know of that the planning board has been asked to staff at this point.
And the CEA, is there a representative?
That's me.
Oh, I'm sorry, the CEA.
and
Sorry,
Nuwari? Right.
Oh, Nuwari too.
Yeah, but that's not really planning board appointment.
It's
No.
not a planning board appointment, but they were happy that I was on the planning board because.
Right.
So maybe that's not official, but unofficial. It's good to have people from different boards as well.
So
Okay,
right now, I'm just trying to, because I'd like to get we've reached out to the boards for their appointments on the Affordable Housing Committee. And next week, we have the special meeting. I think we received 15 applications for the 2 at-large positions. We need to make a choice. And I'd like to get the first meeting set up for the end of September, beginning of October. So I need to know who the board wants to assign to the Affordable Housing Committee, 2 people, and to work on the action plan. I think there's probably more work for us on the affordable housing side, because we are chairing that. I mean, so we are running that program. And Kate's basically running the action plan, and she wants a planning board member to participate.
Well, personally, I'm very, very interested in affordable housing, and with time and energy being limited, and I'm also serving on the Community Preservation Committee. So that's the limit of what I want to do. So,
Those 2 committees.
yeah.
Okay. And Adam, were you going to do affordable housing?
No, I was on this, the CEA, and between chairing that and this, I can't, my wife, will slaughter me. I can't add more committee.
Tell her I
members.
have a good divorce lawyer.
I thought Natasha expressed an interest.
I'm interested in the affordable housing and I'm interested in the climate action plan. Those are the two that I'm interested in general.
Do you have time for both?
That's the question. Can I think about it overnight since it's
Sure.
11? Since it's 11.
That'd be great. If you could do both, I'd appreciate it.
I know Kate said to me, I would love to have Natasha on that committee. I said, well, she's already talked about the affordable housing one, so.
Yeah,
Okay.
think about it.
But they're two pretty, they're two really important pieces of work that are
I
gonna,
know.
accomplish a lot.
Well, who else in this group? Jean said she was interested in affordable housing. Who else is,
Well, we're thinking of having both of you on the affordable housing, having two
okay.
members on affordable housing.
And then one of you would chair it. And so, it's gonna have a representative from, two representatives from the select board, it's late, I'm getting tired. The finance committee, the CPC, the school committee, was it Park and Recs, the Board of Health? I'm tired, I'm sorry.
Yeah.
Okay.
And two at-large members. And it's going to be staffed in large part by Karen Sonneborg, who's the housing specialist, who has done a lot of these affordable housing plans. She's on our staff.
Okay.
And of course, there will be community meetings around this and looking at, affordable housing options and policy and implementation strategies.
I think you're going to be able to rely on Karen for a lot of.
You're going to be able, you're going to be able to rely on Karen to provide a lot of the background information and to do a lot of the actual drafting.
Folks, it's after 11. I really want to adjourn.
Okay. So I'll send you an email tomorrow when I can think straight.
Okay, fine. Okay,
Motion-
that's all I really needed to accomplish tonight.
I move to adjourn.
Somebody second, please.
Second.
Thank you. Jean McKnight,
Aye.
Natasha Espada,
Aye.
Adam Block,
Aye.
Marty has left, so the chair votes aye. It's 4-0. We're adjourned. Good night, all.
Night. Thank you.
Well done, Paul. Not easy tonight. You managed that very effectively.
Thank you. I appreciate the compliment. I went
Yes,
too
yeah.
late.